Okay. Good afternoon. How are you? I hope all of you are fine. Okay. So what was the last topic that we were discussing? Yeah. Please let me know the last topic that we discussed. Okay. Okay, fine. Just a minute, we'll start. Okay, so we're discussing Article 21, procedure established by law and the due process of law. Okay, so I will continue and complete till the directive principles of state policy. Okay. So just I want to complete my part till fundamental duties. I think all of you are aware that the class is till 8:30 today, right? Okay. So what we'll do is we will try to have the class 2 hours, like for 2 to 4 o'clock we'll have 4:10 like that, and then 15 minutes let's take break, another 2 hours let's discuss the class, and then let's have a break of 15 minutes and then another 2 hours. Okay, so that we can be productive. Okay, is that okay for you all? Good. Okay, so please enable your videos now. I'll still start. Okay. So Article 21, a small idea I'll be giving you: procedure established by law and due process of law. Procedure established by law means there will be judicial review or there may not be judicial review depending upon the procedures that is established in the Constitution, the points that is given in the Constitution. There shall be judicial review, there may not be. But in due process of law, there is absolute judicial review. So in India, Article 13 and 21 talks about judicial review. Article 13 says whenever there is a fundamental right violation by a law for any articles, that can be struck down by the court of law. But any law related to Article 21 is not subjected to judicial review. That we know that it is there in order to protect the preventive detention. I'm just giving a review, recap of what we have seen already. Okay, so to protect preventive detention laws related to Article 21 is not subjected to judicial review. Okay, until 1973. So 1978. After that, they have changed the meaning to due process of law. So now even preventive detention laws is subjected to judicial review. Okay. So now, whether right to life is right to life. Right to life, whether right to life in Article 21 is equal to right to die. This is a major question in many countries. They have recognized right to life as right to die. Suicide is a criminal act in India. Okay. But in other countries and all, they've said if a person is having the right to live, the person is also have the right to die. Okay. If he feels that no purpose thereafter to live, the person can be subjected to himself to suicide. So in 1970s, what happened is people went for discussing that right to life should be equal to right to die. So suicide should be decriminalized. Section 309 of IPC says that suicide is criminal act. So they wanted to remove it. Okay, just imagine a fellow commits suicide, attempts for a suicide, and luckily escapes the attempt. Okay, and now if you go and say that you have attempted for suicide, so you'll be arrested. It is like double jeopardy, like double punishment for the individual. Just imagine. It's inhuman. The person requires social support. So that is why they said 309 should be removed. It should be decriminalized. No more suicide should be criminalized. So 1970s, Supreme Court did it. Okay. But what happened is there was a dowry death case. Section 306 says that abetting suicide, abetting suicide is also a criminal act. Abetting suicide is a criminal act, which means inducing somebody to commit suicide for some reason is also a criminal act. Okay. Now, mother-in-law was there. Okay, she has induced her daughter-in-law to commit suicide. Okay, immolate herself. She died. She was arrested. The mother-in-law was arrested. Father-in-law was also arrested under Dowry Act, and they were sent to prison. Now, this mother-in-law filed a case in the court of law, telling that if right to life is right to die, suicide is no more a criminal act. Okay, if committing suicide is like exercising the fundamental right, I have not abetted my daughter-in-law to commit a crime, commit suicide. Rather, I have helped my daughter-in-law to exercise her fundamental right to suicide. The judiciary shocked. Okay, it's of course no. When suicide is not a criminal act, abetting suicide is also not a criminal act, right? So 309 is the head, 306 is the tail. When the head itself is gone, no purpose for tail. Okay, so the judiciary immediately changed the provision. Okay, declared no right to die. Right to life does not mean right to die. And they re-established 309, saying that suicide is a criminal act. Once again, they recriminalized 309. The judiciary said, okay, the act of judiciary of nullifying 309 is not valid. Hereafter, that is after 1972, 309 will be there, and suicide is a criminal act. Anybody who is committing the suicide will be, or attempting for suicide will be arrested, okay, and punished. But the inhuman nature of this act, still remains. Okay, so what they instead of going to right to life and right to die, that concept and all, okay, in 2017, Mental Health Act has been created. The Mental Health Act of 2017, it said that whoever is committing suicide will be considered to be person with mental illness. So if the person is mentally ill, depression, the person cannot be subjected to any punishment. Okay, so the Mental Health Act of 2017 will overrule 309. Now you might have asked me, sir, directly they could have gone to IPC and strike down the 309, right? They would have repealed 309. Why should they create another act and still keep 309 as a criminal act? Because there is political suicide, chances of political suicide. What is the political suicide? Sometimes people will say, I will be fasting until death if the government is not taking a particular decision. Okay, sometimes some people will climb up a big building, will threaten that I will jump. Okay, if something what they're demanding is not fulfilled, right? So now such kind of threatening and all should be stopped. Otherwise, everybody will do that, right? So there are some acts, okay, which is done to threaten people. Okay, there are real suicides or personal suicides. Okay, for personal issues or reasons, people commit suicide. So those suicides which is committed based on pressure or some social issue, personal issue, those people will fall under Mental Health Act 2017. Those people who are committing political suicide, they will be arrested under 309. For example, there is a activist called as Iram Shamila. You know her, any of you? Why she's famous for? She's known for fasting for 16 years against AFSPA, Armed Forces Special Power Act. Okay, in internal security case, they will explain you what is AFSPA. Okay, it gives extraordinary powers to the military. Okay, so military was misusing it over the Manipuri women. Okay, especially in 2005, there was an issue. Okay, where Indian Army raped many women. It is alleged to be, okay, we are not the exact data. It is alleged that Indian Army raped women, especially in the northeast states. So she was fighting against the act. And how come she is living for 16 years? If you don't eat food now, how come you can live for 16 years? The government of India arrested her under 309 of IPC, telling that she's attempting to commit suicide and force fed her. Now, if 309 is not there, if somebody is committing political suicide, you cannot arrest them. See, they are also citizens of this country. They have to be protected, right? Even though they are protecting the government, they have to be protected. Their life is precious. So in this case, if you don't have 309, government cannot arrest them. So that is why political suicides should be avoided. Okay. See, you may say, sir, why can't the government change the law? Just because one person is, dying or threatening to die, okay, you cannot change the law. Law may be good. Maybe that person's perspective may be bad. Okay. So political suicides has to be prevented. That is why still 309 is there. And the 309, okay, since it is there, 306 is also there. So if you are abetting for suicide, inducing suicide, you will be punished. So this is related to political suicides. And there is euthanasia, mercy killing. So euthanasia means mercy killing. If somebody is having a chronic disease, a retrievable status, okay, if somebody is being affected with uh, some kind of disease which they feel is giving them more pain, then you have to kill that individual. Okay, that is called as mercy killing. In certain countries, mercy killing is allowed. But in case of India, we are allowing for euthanasia, but only passive euthanasia. There are two types of euthanasia, passive and active. Okay, passive euthanasia and active euthanasia. Active euthanasia is you are giving a lethal injection, some poison, okay, is injected into you, and you are and life is ended artificially. Then it is called as active. Passive means they will just stop medications and remove the life support systems. Okay, and then allow them to have a natural death. Okay, in India, active euthanasia is not allowed because in the name of euthanasia, people will go for murder. Okay, and you know the responsibility also will go. For example, so a year before, there was parents from Andhra Pradesh. Their child was facing some disease. Okay, so they have to spend a lot of money to protect the child. To spend a lot of money. So they demanded, people to support them. Nobody supported them. So they declared that they want active euthanasia for their child, because they are not able to spend any more money and they also cannot see the child suffering. So put an end. But in that case, the child's condition was retrievable. Okay, some more treatment, the child can be cured. The only thing is they don't have the enough money. So what will happen if you allow for active euthanasia? In the name of active euthanasia, the people may not take responsibility of their relatives, their children or their parents. They will just directly go for active euthanasia. That is why passive euthanasia is only allowed. Any doubts? Okay, fine. So there is some case related to it, that and all they will not ask because it is a 4-year-old case. So don't worry about the case laws and all. If you ask, sir, is there any procedure to go for passive euthanasia? Yes. Okay, first a medical team of doctors should declare that it is a irretrievable condition. It is a case for passive euthanasia. Then independent doctors should cross check. Independent doctors means not the family doctor or the doctor who's treating the patient. Some other doctor should also certify that it is true. Okay, and this doctor will be definitely a government doctor, okay, appointed by the judicial magistrate. And the judicial magistrate also should see that it is a case for passive euthanasia. After permission only, it will be done. Okay. So now some of you may ask, sir, when our family and all, there has been incidents when elderly person is suffering in the hospital, doctor will ask, okay, telling that, even if you give treatment, it is not worthful, the person will die. Okay, like that, the doctor is giving, you would say, okay, then stop medication. See, that and all, only after the multiple organ failure is starting to happen, they will say like that. Okay, and that too, they will say that, okay, let us keep them in the ventilator. If they're coming back, fine. Okay, let's not put any extra injection or any expenditure, because even if you do that, it will not be helpful. Okay, so that is and all is not called as euthanasia. Now the thing is, euthanasia is when you are alive, there's no brain death. Okay, in that case, if you have to end the life of the individual, okay, under article 21, it can be done only by passive euthanasia. Okay, now interestingly, there is a practice called as santara by the Jain community. Okay, santara, Jain, meaning they'll fast until death, okay, in order to achieve moksha. Okay, moksha means salvation, okay, going to the god. Okay, eternal life, they say. Now, whether it comes under suicide, this was a question. Rajasthan High Court said it's a suicide. Okay, so we should not allow. But however, Supreme Court said that no, this practice can be allowed, because actually why people are having starvation, why they are starving, to achieve moksha. Moksha means eternal life. It's not that you are putting in, you are enhancing your life. So according to Hindu philosophy, okay, if you are achieving moksha, that is the ultimate goal of life, right? And your life is permanent now. So the persons is not ending their life, okay? So they are trying to fulfill their purpose of life of achieving moksha. So this will be allowed. Santara will be allowed. Indian judiciary is a very unique judiciary. They not only check the constitution, but also they read the scriptures. Many Islamic law also. Okay, Muslim personal law, Christian personal law, Hindu personal law, Parsi personal law. Before giving the judgment, they refer to their respective scriptures also. Indian Supreme Court is the only court which refers to scriptures, okay, and philosophies, religious philosophies, not to arrive at the judgment. Now that is once again, India is a positively secular country. We are not, cutting down ourselves from the religion completely. Okay, we agree that religion is part and parcel of our lifestyle. Okay, done. So Article 21, as I told you already, there are some inferred rights. whether to read this inferred rights or not, as I told you, just go through once. You'll be using in the third paper. Okay, you cannot use it in the anything. Is inferred rights, okay, only if it is in current affairs, memorize, okay, that which under which article it is coming, article 21 or 19. Otherwise, okay, you need not, break your head on memorizing these points in the book, okay. Fine. Now let us talk about article 22. Article 22 talks about rights with respect to conviction for offences. Rights with respect to conviction for offences. Okay, so before going that, can suicide under mental health act is arrestable? No. Under mental health act, personal suicides is not a punishable offense. Okay, because you are under mental illness. No, those who are doing crime in mental illness, they will not be punished. Okay. Then passive euthanasia comes under which article? Article 21 only. That is why we are discussing passive euthanasia here. Any other questions before we are moving to article 22? No, no. Inferred rights is under article 21. Okay, we are completed inferred rights. Okay, that is right to dignity, right to clean environment, right against handcuffing, right against public hanging, right to medical treatment, emergency medical treatment, right to information, right to education. Like that, we have a big list of inferred rights under article 21. When it comes in current affairs only, you have to read about that in depth. Otherwise, you can leave them. Okay, fine. Now, article 22 talks about. I'm sorry. Sorry. Article 20. This is article 20, which I typed in. Okay. So protection available for people who are arrested. Protection available for people who are arrested. Okay, fine. What are the two types of arrest that can be made? As you know already, punitive detention, preventive detention. We have already saw the meaning of this punitive detention and preventive detention. So punitive detention is when you do a wrong and because of that you are being arrested, it is called as punitive detention. Preventive detention is you have not done the wrong. The government suspects that you may involved in the act. Okay. In that case, the government may arrest you. Okay, that kind of arrest is called as preventive detention. Now, arrest can be executed by SI itself, the sub-inspector level itself, they can arrest. Okay, so there are many SIs, thousands of SIs are there. So just if they are having a conflict with the neighbor, they can go and arrest them. Okay, fine. What are the two types of arrest that can be made? As you know already, punitive detention and preventive detention. Preventive detention is when you do a wrong and because of that you are being arrested. Okay, so So that should not happen. They should not misuse their power of arrest. So that is why the Constitution gives these rights. What are the rights? Okay, for punitive detention, grounds of arrest must be told. Grounds of arrest must be told. When I say grounds of arrest must be told, they will tell under which section the person is going to be arrested, which section is violated, okay, how he is going to be arrested. This is called as grounds of arrest. So supposing murder means 304, suicide means 309. So the police has to tell you which section, under which section is you being arrested. Now, you must know that there are two types of offenses, cognizable offense and non-cognizable offense. Cognizable offense and non-cognizable offense. The word cognizable offense means you know the crime has taken place for 100%. For example, you're seeing a dead body lying in the floor with a gunshot on the head. So definitely either it is a suicide or it is a murder. Okay, so both can be the case. So the police is 100% sure that the case has taken place. But there are other offenses non-cognizable. For supposing you are going to the police and complaining, sir, person A has threatened me. Person A has murdered me. Sorry, threatened that I will murder you, or the other person has defamed me. The police may not know whether the crime has taken place or not, so they'll call both the parties. Okay. So when both parties are coming, the police does not know whether really the crime has taken place or not. So they'll ask the two parties to go to the court of law, then confirm the crime. So in non-cognizable offense where crime is not able to be confirmed, police cannot take any action. But in cognizable offense where the crime is 100% sure, the police can initiate action. Meaning they can file FIR and they can initiate arrest. Arrest can be initiated and FIR can be filed. It's called as cognizable offense. Now, why police is allowed to arrest in cognizable offense? See, when the crime has taken place, the first 24 hours is golden hours of investigation. Meaning, you will be able to collect all the evidence then only. Otherwise, after one day, evidence will automatically go, or it may be tampered with, or it may be deleted by the perpetrator of the crime. So when a person does a crime, no, immediately within one day, you'll be in a shock of that crime. Okay, will not be able to uh, remove all the evidences. Okay, in a hurry of escaping from the crime scene, the person will miss the evidence and go. But one day later, he will definitely eliminate all the evidence. Psychologically, they say when a person commits a crime and runs somewhere, the person will come back to the crime place again to see what is happening. Okay, so that is why the police will wait for if any suspected movement is found in that place. Okay, so many people have been caught this way, and moreover, memory of the people will also fade sooner. Okay, suppose there is a crime scene. Today you have seen a person, you will remember about that person. Okay, how he looked like, what was his dress, okay, what was his thing, all the things you will be remembering. But after 1 week or 2 weeks, if you are asking a person, the person will say, I'm not sure of it. Okay, exactly sure of it. Grounds of arrest must be told. Next is, so in this, yeah, before that, this grounds of arrest, no, uh, why it has to be told. So there may be some offenses which is cognizable, other offenses not cognizable. Only in cognizable offense, the police can make an arrest because the golden hours of investigation is there. So immediately they have to make the arrest. The suspect will be nearby, so immediate arrest can be done. If not, the person will escape. Okay. Now, as an ordinary person, do you know whether a particular offense is a cognizable offense or non-cognizable offense? You don't know. So that is why section of law has to be told. The police has to say under which section they are arresting. Okay. Now, if it is a cognizable offense, you can go with the police. Otherwise, you can ask warrant to the police. You tell the police that you give me the order issued by the court of law for non-cognizable offenses. Since you don't know what is cognizable and non-cognizable offense, the next point is lawyer could be called, okay, to defend you, and the police should allow you to communicate with the lawyer. To defend the lawyer and then to communicate with the lawyer. So the lawyer will see whether it is a cognizable offense or non-cognizable. If it is cognizable offense, the lawyer will ask, you to cooperate with the police. Otherwise, the lawyer itself will talk to the police and say, leave my client. Okay, it's a non-cognizable offense only. We will meet in the court of law. Then the third point is, once you are arrested, you should be produced before the magistrate within 24 hours. Okay, excluding travel time. Okay, no travel time. Holiday. Okay, travel time and holiday will not be. Okay. Now, why the person has to be produced with 24 hours? Okay, the police may be wrongly arrested a person, or the police might not have given the rights to the person. So when the person is produced before the magistration, the first question asked by the judiciary is whether you have been communicated to your lawyer, whether your grounds of arrest has been told to you. Like that, the judiciary will ask questions. And judges will also see whether there is prima facie evidence against the individual. Prima facie. Okay, I'm using this word. Prima facie means at the first look, at the first instance. Okay. It's not like, there is a big discussion and all. Like, I mean, big inquiry, arguments, evidence is produced. First of all, whether the suspect is having any relation to the victim, whether the person might have done the mistake, any chances are there. If there is no chance, there is no link, the judiciary, the judge will release the person. Okay, the person has the right to be released. Only if the judiciary is convinced that, okay, primarily it looks like this person only would have done the mistake, then they will allow the police to take the custody of the person. So to ensure that there is no wrongful arrest only, you are produced before the magistrate. Suppose if the police arrests you, and sometimes this happens, okay? Sometimes police will arrest you in the morning. By evening, they leave you. Is it possible? Yes, it is possible. Okay, but maximum 24 hours only. After that, if the police is extending the custody, then it is a violation of the fundamental right. You can go to the court of law. Court will ensure the person is free. Okay, why travel time and holiday is not there? Okay. So, of course, judicial holiday means you cannot get the person to the magistrate. Okay, so holidays they will be in the jail only. That is why when VIPs were arrested earlier, they'll be arrested exactly Friday evening, so that 2 days they can be treated well. Okay, in the prison. And after that, in one of the cases, the High Court had given an issue. Sorry, issued an order saying that when VIPs are arrested at any time, odd time, immediately you proceed before the magistrate. Okay, you can take the person to the home of the magistrate and take the permission. Okay, it is not must that you have to wait for the holidays to be over. Only for VIPs. No travel time. Usually, when the people do crime, they fly off to some other place. I don't know what is the connection between Tamil Nadu and Bihar. Okay, anybody who is doing crime here will run to Bihar. Anybody who is doing crime in Bihar will come to Tamil Nadu. Okay. Now, the police, if they want to arrest and bring back these fellows, travel time itself will 24 hours. Okay, train more than 24 hours. If you include travel time, in between that fellow will ask 24 hours time period is over, so release me. That is available for a person during the arrest. Okay, where this protection is not available. These protections are not available. Preventive detention. See, I told you what is the purpose of Article 22. That even a level of SI can make an arrest. So many a time, they can misuse the power of arrest. I'm sorry. So that is why that 4 protections is there. But in case of preventive detention, order will come from a higher official, not the inspector or at least the DIG. Okay, level you should, or superintendent of police. They have to give the order for preventive detention. So when the order is issued from the higher level, when the order is issued from a higher level, no need for these 4 protections. So preventive detention, these 4 grounds is not possible. Okay, so you need not produce before the magistrate because you have not done any crime. No need to be communicated with the lawyer because you have not done any wrong. Only when you do a wrong, you will be thinking whether it is a cognizable offense or non-cognizable offense, right? But in case of preventive detention, you're not doing any wrong. Okay, so these 4 protections will not be applicable. Then for civil arrest, these 4 protections is not applicable. See, for criminal offense, only there is arrest, imprisonment. But in case of civil arrest, there is no imprisonment. Or sorry, civil wrongs, there is no imprisonment. But here we are seeing that there is civil arrest, meaning, I'll give you an example. Suppose there is person A, person B. Both are having property dispute. Person B is not attending the court of law at all. Okay, person A is not attending the court of anyone. Now, to ensure the person is attending the court of law, if the court is issuing an order of arrest, that arrest is called a civil arrest. Okay, so arrest is not for punishment. Arrest is to produce the person before the magistrate. Okay, for further trial of the law. It is called as civil arrest. Okay. Now, there is another arrest, civil arrest. For maintaining law and order. See, now the farmers' protests are taking place. Okay, supposing the farmers are blocking the traffic. We want to clear the traffic. Okay, you have to ensure smooth traffic. So to maintain law and order, if you are making an arrest, that is called as a civil arrest. These kind of arrest will be made in the morning and the person will be left before 6 p.m. in the evening. So no need of telling the grounds of arrest. If you keep telling the grounds of arrest, you will not be able to complete the arrest itself, because when large number of people is protesting, you have to mass arrest. Okay. So the arrest that is made to maintain law and order, these four protection is not applicable. But in case if the government feels, the police feels these people when let off will once again go and block the traffic, they can extend their detention, but only with the permission of the judiciary. Civil arrest is maintaining law and order. Okay. Then citizen arrest is there. That is, whenever you see somebody is being stabbed on the road or a crime scene, you can catch hold of the perpetrator of the crime, the wrongdoer, and submit the person to the police custody. So such kind of arrest is called a citizen arrest. You and I, when we make an arrest. In these cases, also these four protections is not applicable. Fine. Now we have to talk about next clause. Okay. Article 22, clause 2. That is protections that is available during preventive detention. Preventive detention. Okay, Article 22, Class 2 is preventive detention. Just give me a second. 1 minute. 1 minute. So why this different classes are there? Article 22 class 1 and Article 22 class 2. Why we have different articles? Because Article 22, okay, class 1, that is this one, protection available for people who are arrested, punitive detention. It is not applicable for enemy alien. Okay, Article 22 class 1 is not applicable. Alien means foreigner. Here the word alien means foreigner. There are two types of foreigners, friendly foreigners and enemy foreigners. Friendly foreigners are those countries with we are having peace. Those countries with which we are having war, their citizens are called as enemy alien. See, the idea is, okay, supposing India and China is declaring war. Automatically, when the war is declared, Chinese people will be sent back to, okay, China. China will take back its civilians. What if some Chinese people are living in India, they say that even if the war is there, we will stay back in India. They may act against the interests of the country, so they can be arrested and deported immediately. At that time, no need to tell any grounds of arrest and other things and all. Okay, no need to produce the person before the magistrate. Since the person is an enemy alien, it can be arrested and deported immediately. But Article 22 class 2 is applicable even for enemy aliens, for citizens, friendly foreigners, any enemy foreigners, all of them can exercise the rights that is given under Article 22 class 2. Suppose Indian government has subjected a person, okay, and if the Indian government feels that the person may do a wrong, okay, the person may be subjected to preventive detention, okay, but only for 3 months. And certain rights has to be given to that individual. Okay, so what are the rights for the preventive detention? Here also grounds of arrest must be told. Grounds of arrest must be told. Very good. Fine. Grounds of arrest is told. Meaning, what is the reason? Now you may be asking, sir, earlier grounds of arrest means section of law should be said. But in preventive detention, the person has not done any mistake. Okay, which section we will be telling? Okay, because he has not done any mistake. Yes, the person has not done any mistake, but you have to tell the reason, the purpose of arrest. Okay, here grounds of arrest means purpose of arrest. The person who is subjected to preventive detention can make an appeal to a higher court of law. They can make an appeal. Now, the maximum detention period is 3 months. The maximum time period a person can be detained is 3 months. They changed it to 2 months actually, but they have not notified it. Okay, so as of now, it is 3 months only, even though the change is there. Now, preventive detention is taking place. Maximum time period a person can be in prison only for 3 months. After 3 months, the person has to be released. Now, what if the government feels the person has to be detained even after 3 months? Okay, if the detention period should be extended, they should refer the matter to an advisory body. This advisory body is known as an ad hoc body. It's created, and it's an ad hoc body created by ad hoc means temporary body created by the government with retired judges. So they will see the case whether it is a specific case where the detention can be extended or the person should be free. Whatever advice that is given by the advisory body is binding on the government. Very important. Okay, please don't get confused. Just because the word is advisory body doesn't mean its advice is just an advice. It is binding on the. But binding means the government should accept. There's one more thing. Okay, Preventive detention laws can be created by Parliament as well as State Legislative Assembly. Preventive detention laws can be created by both Parliament as well as State Legislative Assembly. And moreover, for a specific crime, for example, terrorism, the Parliament and the State Legislative Assembly can create a law and increase the detention period. Increase the detention period. Okay, increasing the detention period. Specific crime. Okay. So they can fix 6 months, 1 year like that. Okay. For example, terrorism 6 months like that, they can increase. Now, the point here is in Article 22, Class 2, preventive detention, we are having three protections. Okay. So what are the three protections? Grounds of arrest must be told, appeal, and maximum detention is 3 months. That we are telling. Okay, fine. But they are weak provisions because in the name of national security, you need not tell the grounds of arrest. Now, appeal process takes some time, okay, for you to be released. And maximum detention, we can say that it is 3 months. But however, it can be extended by advisory board. The advisory board is appointed by the government. So they can appoint their favorable people. And moreover, Parliament and State Legislative Assembly can increase the detention period. Okay, so overall, the protection that is available for preventive detention is not so strong. It's not so effective. It's weaker. Done. Okay, now we have to talk about the next articles, Article 23 and 24. They talk about right against exploitation. '23 and 24 talks about right against exploitation. Okay, if you have any doubts, you can ask, then we can move on to this rights against exploitation. Yeah, Jammu and Kashmir politicians, yes. Okay, preventive detention only. Okay, preventive detention only. You set up an advisory body. Based on that advisory body only, they will be extending the detention. Actually, Jammu and Kashmir leaders has been subjected to arrest by Public Security Act. Okay, thereby 6 months they can be imprisoned. And moreover, one of you are asking, sir, what if after 3 months the government is releasing the person, once again subject them to preventive detention? Yes, that is also possible. Okay, that is why there is a big chance for misuse. Usually our government, what does it know? 3 months after over, instead of setting up advisory body, they'll release the person. 1 week they'll wait. Once again, they'll go on arrest. Another 3 months. Okay. There has been instance in which preventive detention was done and a person appealed in the court of law and the court released the person. Okay. Now this person happily was getting down the stairs of the court of law. The police went and said some other reason and subject the person to preventive detention. The government is hell bent that you have to be inside prison. They may misuse the preventive detention laws. That is why we are saying that preventive detention laws are bad. Okay, the previous class we saw now. Fine. So what does Article 23 say? Okay, Article 23 prohibits human trafficking. Okay, prohibits human trafficking. What is human trafficking? Buying and selling of human beings. Buying and selling of human beings. Okay. Slavery system, right? Like money will be fixed on the individual, and that now when you buy and sell women or children in order to force them into prostitution. Buy and sell children in order to force them into prostitution. Then also it is a violation of constitution. See, prostitution is legal in India as long as it is voluntary and it is happening in the private place. In fact, it's not called as prostitution, it is sex with consent. But when you are forcing an individual to do the prostitution, and through that you are getting commission, you are doing it in an institutional way, then it is a illegal thing and the arrest can be executed. Devadasi system is abolished. What is this Devadasi system? Young girl children will be devoted to temple and they have to uh, learn music, dance, and other cultural aspects. Whenever they are required, they have to provide services to the temple. Okay, so this system was called as Devadasi system. But as the time went on, people were subjected to exploitation. Those who are Devadasis, those people were subjected to exploitation. Including physical harassment and sexual harassment. Okay, so what they did is uh, they said that it is an exploitative situation, so they've abolished it under Article 23. Because there is no choice for the individual. When a child is their girl child, she does not know how to decide. They are forced into the service of the religion. And also there is no way out. Now, some of you may ask, sir, what about Christian nuns? They are also getting into nunnery engage. Jain, Buddhist, okay, nuns, they are also entering into young age. Why can't we call that as exploitation? Why in Hindu religion alone we are calling as exploitation? Because in case of other religions, there is a way out. If you don't feel, no, after you becoming an adult, you feel that your parents have made a wrong decision, you can very well come out of the uh, institution. Okay, if you are in a Devadasi system, no, there is no way out. Okay, you will be seen as the wrong person, one who have denied the society. Okay, and you will be subjected to social boycott if you come out of the system also. Okay, so there is no way out for Devadasi system. And no, in my view, okay, even in other religions, okay, people has to take up to religious institutions only after their adulthood. Okay, when they are young, when they are as a child, okay, they should not be allowed to take the religious priesthood. Okay. So it should come only after 18 years, because to do it as a child, no, the child does not know anything else and it is conditioned to take it up. Okay. Many times, no, we are finding that religious people are doing corruption. The reason is in the young age they would have been forced into the priesthood, and after becoming an adult, they will be happy with the pleasures of life, want to enjoy the pleasures of life, so they may involve in any act. so Devadasi system is abolished, and slavery system is also abolished under human trafficking slavery system. In India, we did not have the practice of slavery, but as a precaution, we have introduced this term in the constitution, telling that in case any practice like slavery is happening, it will be done away with. Okay. Then forced work is also prohibited. If you don't like a work, but you're still being insisted to do that work, it is a violation of your fundamental right. So remember, Article 23 and 24 is subjected to private individuals also. Not only the government, but is also against private individuals. I'll repeat, Article 23 and 24 is available against government as well as private individual also. Okay, fine. Now, supposing you are making a bond with a company. This bond is legal. Yes, bonds are legal. But if they're making a bond telling that you will give you one job and they're giving some other job, then you have every right to resign from the job. Usually, in IT companies, they will tell you you are a software engineer and they'll recruit you. Okay, but what you will be doing is cut, copy, paste from the, either you will be a database manager, okay, or you will be doing testing, okay, or you will be in a call center where you are replying for the functioning of a laptop or a printer like that. Okay, if some error is happening, they're calling, you will be okay. But in this thing, they would have said it's a software engineer. So you promise one job, when you go inside, you find that you don't like the job, you can very well resign from the job. Now, what if, yes, somebody has raised their hand. Yes, you can unmute and speak. No response. Okay, so no first work. Supposing you are taking a bond with the company, okay, and you want to resign from the company before the bond period itself. Whether you will be to do that, yes, you can very well resign from the post. How? The company can just retrieve only your or the only the amount which is they have spent for your training. They cannot take the salary. Okay, salary cannot be withhold. Sometimes some companies will say, I'm withholding the certificate. Okay, I'm withholding your caution deposit. In fact, caution deposit itself you should not get. If the company says like that, okay, you should not leave it. Okay, you should not uh, agree with it. You can file a case in the court of law. No company can withhold your certificates or some amount. Okay, only the amount spent on the training can be taken back. Okay, that is the validity of bond period. Okay, supposing 2 years bond they have put. Okay, so for 2 years, whatever amount they've spent on your training, they would have earned from you. So after 2 years, if you are resigning, even the amount that they've spent on your training cannot be taken back. Okay, fine. So there is no forced work, and beggar system is also abolished. See, you should not confuse this with begging. Beggar system means work without remuneration. The word remuneration means Okay, compensation in the form of money. So when you work, okay, you have to give compensation in the form of money. Work without remuneration. Okay. So in case of India, the British government wanted more protection of indigo plant. So they requested the farmers to grow indigo plant for free. Okay. So this is what we call as beggar system, when you demand work without any remuneration. Now India also, there is a system called as Jajmani system, meaning there will be poor people who are associated with a rich person. Now when there's judgment, in Tamil they call it as Yajaman. Okay, for that person, they will be providing all type of services like washing clothes, cutting hair, okay, and rearing their cattle. Okay, all the works will be done. Now if they want some food, they will have to go and ask the people who are there providing service. These people who have done the service will be provided with old clothes and old food. The food is which is remaining. Okay, that only will be shared with these people. See, when they do the work, they have to get money, right? Instead of money, they get old clothes and the old food. And that too, the quantity will be decided by the master. Okay, so this is also called as beggar system. It is prevalent in the village areas. So the Indian constitution says such kind of system where there is work without remuneration is a beggar system. Now you may ask, sir, even in companies, they're giving fringe benefits. Okay, can we agree with that? Okay, so the basic pay should be in cash. Other benefits, allowances and all can be in kind. Okay, but the basic amount that is given, that should be a cash only. Okay, otherwise it will be a beggar system. Now you may be asking, sir, what if a person is asked to do overtime and no payment is done? In case of that, no, it can also be treated as beggar system. When a person is less paid, that is beggar system. When the person is not paid the minimum wage in a particular state, then also it is beggar system. So beggar system is, if you don't get money for your work, appropriate money for your work, then it is beggar system. It is a violation of constitution. Fine. Bonded labor also is abolished. Now, I told you there is no forced work, but there is an exemption for it. The government can exempt, or the government can ask people to do work for the government. The government may not pay the money also. So there you cannot say it is a forced work, it is a bonded labor. Okay, or it's a beggar system. You cannot say that. Government can call any of its citizens to support its action. Okay, to work under the government compulsorily. But when the government is calling so, it should not discriminate on the basis of race, religion, caste, and class. Race, religion, class, and caste. See, in Article 15 and 16, we had other features, right? Gender is missing here. So, which means what? The government can call gender specifically. For example, there is a war. women and children has to be protected. So only men can be asked to come and fight. Okay, fine. See, class means what? Economic class, poor people, rich people, like that, division should not be there. Everybody should be called for the service. Otherwise, government may use the emergency situation in order to push through their idea of genocide, okay, killing a particular group of people. That should not be happening. Now, there is a concept called as military conscription. Military conscription. That is compulsory military service. In India, we don't have compulsory military service. Military conscription is not there, but other countries they have. Okay. But why we don't have in India? Because already when people are recruited for army, willingly people join army. Okay, because they will get some benefit in future, right? So willingly they join the army. But however, in future, we are reserving the right to have military conscription by telling that government can go for forced work. In future, the government may decide on military conscription, so every citizen may be trained in army. Okay, any doubts here? Okay, so Article 23 is over. Now Article 24. Before that, I will take few questions already asked. Sir, will forced work include housewives who were not allowed to get jobs? You can file a case. Yes, very well. If you feel it is a forced work, okay, it is assumed that you are doing the work voluntarily. Okay, if you feel that your husbands are, don't tell it to my wife, no. Okay, you can file a case, okay, telling that you are subjected to forced work. The state will say, please don't, force the women. Only if they're willing, you should voluntary, fine. Or if it is forceful element, yes, you can file a case. So I think Archana, you will be filing a case against your husband. I just worry for him actually. Okay, fine. Okay, that was a good question actually. Now, in another class, I got another question. Very, sir, when we were children, our parents were asking to do homework forcefully. Okay, so is it forced work? See, children cannot decide for themselves. So, as per law, until 18 years, the parents have the right to decide for their children. Okay, after 18 years, supposing your parents are forcing you to do something, you can very well file a case. Okay, then court will come and liberate you. Is bonded labor and contract labor are same? No. Okay. See what is the difference between bonded labor and other types of labor? In bonded labor, you are bound by the master all the time. Okay, so from 24 hours you are like a slave. Okay, there is no private life for you. In contract labor, you are contracted only for 8 hours. After that, you have private life. In bonded labor system, entire family will be under the one master, serving the master, husband, wife, children. Now, when they should sleep, when they should eat, for that matter, whether an husband can have sexual relationship with his own wife, that also will be decided by master only. So, or they live, eat, work, sleep only for the benefit of the master. There is no private life. That is bonded labor. Okay. When you are having your private life, then that is a normal labor. Okay. You cannot equate bonded labor and contract labor. The word itself is bonded labor. The person is tied to the master. He has no private life at all. So there has been a practice, usually in plantations where they'll KGF is a good example. Kolar Goldfields. Okay, part one, now part two. Okay, so it is a good example of a bonded labor system where you don't have a private life. You are confined within a boundary. You can't even go out of there's no freedom of movement. You can't meet anyone. Okay. Okay. So such kind of thing is no, it's like cutting down the very human nature itself. That is why it is bad, bonded labor system and contract labor system. Okay. Article 24 talks about prohibition of child labor. Okay. So what do you understand by prohibition of child labor? It says that children under 18 years shall not be subjected to hazardous industries. No hazardous job. Interestingly, when I say no hazardous job, okay, non-hazardous job is permitted. Soft jobs are permitted for children under 18. But we have Article 21A. What does Article 21A says that? It says that compulsory and free education for children under 14 years. Now, when children has to be in schools, here we are saying that children can take up to soft jobs. So there is a anomaly. There is a contradiction between Article 24 and 21A. So that is why what we did is in the year 2016, we made an amendment to Child Labor Regulation and Prevention Regulation Act. Child Labor Prevention and Regulation Act. (2016) Amendment to Child Labor Prevention and Regulation Act. This act, actually says that children under 14 years, no child labor, complete abolition of child labor. There's no more child labor. 14-year, okay, no child labor. 14 to 18, called as adolescents. 14 to 18 year, they're called as adolescents. They can work in non-hazardous industries. Non-hazardous industries. Okay, 14 to 18 years. Okay, they're called as adolescents, and this non-hazardous industries they can work. They are prevented from working in hazardous industries. Okay, so earlier there's work in restaurants. Okay, and domestic work and all was treated to be hazardous industries. Okay, but right now, okay, when a child is working or an adolescent is working in a hotel, other places and all, no more it is a child labor. There is an exemption for this rule. Okay, family business. Children can involve, even the children below 14 years, they can involve in family business. because it is a kind of learning only, family business. But they can involve in family business only after the school hours. Family business, okay, again, after the school hours, they can involve in. What is the meaning of family business? Okay, father or mother's business. Father or mother business. Father's brother or sister business. Mother's brother or sister business. They have defined, okay, what is family business. So you cannot go and work with the extended relatives. Usually, child labor, what will happen is, okay, poor families are there. They will make these children to work in the extended families household, okay, or place or business. Okay, so that should not happen. See, usually how this child labor system works, no, there will be a contractor who brings in the child labor. He will be belonging to a particular village, and he will go to his own caste people, and I'll ask the children to ask them to send the children for child labor. Okay, and these children will call this fellow uncle because belonging to the same caste. Caste is nothing but extended family, right? Okay. Now this person takes all these children and comes to the city, and child labor is being employed. Now, if the officer is asking, why are you here? The child will say, I'm working only in uncle's company or uncle's, employment, because for them, in village area and all, okay, people belonging to the same caste and all, they'll call with the relationship name only. Okay. So now, what happens is you can easily conduct child labor in the name of family business. That is why two checks they're keeping. You can do child labor. Children can be involved in a work in a family business only after the school hours. Point one. Second is it is only for close relative business. It's not in the extended relatives business. Okay, so if a child wants to do a job and work for himself, they can do it after school hours. Because some of you may asking, no, that some of the children parents' income is not enough. Sir, what if they are working in order to settle their fees? Fine, they can do it after the school hours or holidays. Okay, any doubts? Family business. Then some children are prodigies. Prodigy means what? A talented, born, okay, born talent. They're exceptionally good in any one of the things. Okay, singing or dancing or like that. They'll be exceptionally good. Okay, so child prodigies are there. These child prodigies can perform. Okay, if they're singers, if they're dancers, they can involve. For example, they can do acting in cinema, serial, advertisement, and all. Okay, provided their school education is not affected. They're not talking after school hours. Okay, because definitely school hours they cannot attend. Okay, so without affecting their education, they can involve in any activity. So they are allowed in audio visual entertainment also. Okay, audio, visual, entertainment. So these are the exemptions for the child labor, prohibition of child labor. Okay. So only in the year 2016, we have abolished child labor completely under the age of 14. Now, before 2016, if you see a person in a restaurant or a hotel or domestic work, then it is a violation of fundamental right, or it is a violation of law. It is a child labor. But right now, 14 to 18 children, okay, if they are in domestic work or in the hotel work, it is not considered to be a hazardous work. Done. Any doubts in this? Okay, so Article 24 is also over. Now we should be discussing Article 25 to 28. Okay, 25 to 28 talks about religious freedom. Of course, 29 and 30 also, but 25 to 28 is common for all the religion. 25 to 28 talks about religious freedom. Okay, what does Article 25 say? Article 25 talks about freedom of conscience. Freedom of conscience. Okay, and freedom to practice religion, profess religion, practice religion, propagate religion. Freedom of conscience, profess, practice, and propagate religion. There is one person who has asked a question, sir, IPL match they're actioning, can it be taken as human trafficking because they're fixing a money value and they're buying and selling? No, they're fixing the money to the talent of the individual. Okay, now they have a private life. That is why I told you, no. Okay, what is exploitation? Only when you don't have a private life. When you have a private life, we don't call it as a violation. Okay, so now what is freedom of conscience? Now, conscience is the inner voice which says that whatever you do, whether it is correct or wrong. Okay. Freedom of conscience is your inner voice which says what you do is correct or whether what you do is wrong. Okay. So if your heart believes, if your mind believes that a particular religion is a better religion, you can follow it. Nobody can force a religion on you. Nobody can force a belief system on you. It is up to you to follow a particular religion. So that is what we call it as freedom of conscience. Okay, whether we want to follow a religion or not. But professing a religion, meaning you identify yourself with the religion. For example, A Muslim is wearing a skull cap, or a Hindu is having a sacred ash on the forehead, or a Christian is wearing a cross. They are identifying themselves with the religion, okay, telling that I am belonging to this religion. That is called as professing of a religion. And the freedom of conscience, you can identify yourself with the religion. Now, you can call a country as a secular country when somebody is asking you the religion, which religion you belong to. You should be able to tell it boldly. For example, if there is a Muslim and if somebody is asking what is your religion, if you are fearing to open your mouth, then that's not a secular country. So professing is that you should be able to come out and say that which religion you belong to. Right. Next is practice of religion. When I say practice of religion, you can practice ritual as well as ceremonies. Ritual means supposing a Muslim is offering namaz at his home, it is called as ritual. The Muslim is going to the mosque and offering namaz along with his fellow community, then it is called as ceremony. So ritual is done individually, ceremony is done in a congregation. Okay, congregation means a group of people. The beauty is we can practice the religion not only at our home, not only in the place of worship, but we can also practice religion. Okay, you can practice religion in case of public place also, very important. Suppose Christians want to have a procession, or Hindus want, Ganesh Chaturthi procession. Muslims wanted to offer namaz in a public park, or say in Marina Beach in Chennai. They'll be allowed to do that. Okay, so you can practice your religion even in the public place. Very important. Now, they may be having a question, sir, whether all kind of practices is allowed. No, subjected to reasonable restrictions. There are reasonable restrictions for Article 25. Okay, what are the reasonable restrictions? Okay, security, public order, morality, health, and other fundamental rights. Very important. Okay, underline the word other fundamental rights. Okay, so why this other fundamental rights is important? Because, okay, in the name of religion, you cannot violate other rights. I'll tell you, some people argued that we are practicing untouchability, or we are not recognizing Dalits. They're not giving equality to Dalits because it is approved in the scriptures. Is approved in the scriptures. Can we allow for it? No. The practice of untouchability is bad. Okay, so whenever it comes to Article 17 versus Article 25, Article 17 will prevail. Abolition of untouchability. Dalits entry into the temple. Article 15.2 says that there should be no liability in entering the place of public resort. But if Agamas is saying that Dalits should not enter into the temple, like that, Agamas are saying, you cannot say that I am practicing the religion. Even Sabrimala case. Okay, in case of Sabrimala case, women is not allowed entry into the temple. The Supreme Court allowed entry into the temple, saying that Article 15 is primary compared to Article 25, because Article 25 is subjected to fundamental rights, other fundamental rights. Triple talaq. A Muslim cannot say that triple talaq is valid according to Shariat. Okay, the Muslim law. So we will follow it. No, you cannot say, because your religious practice is subordinate to other fundamental rights, women equality. Okay. Whether the government will, allow you to practice all the practices, all the religious practices? No. The government guarantees only for the practice of essentially integral part of the religion. Essentially integral part of the religion. For example, Sikhs are allowed to wear turban in army, whereas Muslims are not allowed to wear the beard the bird. Sorry, to have beard. Why is it so? Because for Muslims, no, having a beard is not a essential integral part of the religion, but for Sikhs it is the essential integral part of the religion. Okay, so the Indian government, constitution, and court will guarantee 100% practice of religion, which is essentially integral part of it. Otherwise, there is no, viability. Fine. Now we must know that these three things: security, public order, morality, and health. These things are non-self-executory, which means it needs a law to be implemented. Already we have discussed this, right? Usually reasonable restrictions will not be self-executory. It needs a law to define what constitutes disturbance of security, disturbance to public order, disturbance to morality and health. Okay. Now in the other class they asked this question, sir, what about in case of temples, they harm themselves. Okay. There are practices to harm them. And in Muslims during Muharram, okay, they beat themselves until blood is coming. Muslims, Muharram, in case of festival called as Muharram, they do it. In some part of the villages, during Easter, Christians will, put nail on their palms. Okay, just like how Jesus Christ was crucified, they'll put nails into their arms. Now, whether these practices could be banned, yes, it can be, but you have to create a law. Animal sacrifices in temples, can it be banned? Yes, it's banned, but there needs to be a law. So usually the government sees which are sensitive areas. So sometimes government it allows for Muharram, and government allows for this. In Hindu temples, people subjecting them to physical punishments. It sometimes appears through the the holy instrument of God, the veil, they will say. Okay, so that would be inserted. So in that cases and all, the government feels that people are doing it voluntarily and it is sensitive, so they are not touching it. Once Tamil Nadu government tried to bring in a law to stop animal sacrifices in all the temples, but it was vehemently opposed, and so the law was dropped. Okay, so that is why even now we find, in temples and other things, animal sacrifice is still being carried out. Because, for many people, it is part of their culture. Okay, so in case in future the government can do it, since government is free to do it. Okay, when government is banning that practice, whether you can go to the court of law, yes, you can go to the court of law. The court will see whether it is an essentially integral part of the religion. So, for example, animal sacrifices, whether it is essentially integral part of the religion, they will be checking. Okay, as I told you, Indian judiciary will check for the scriptures. Okay, what it has said. Check for the canon laws or Sharia laws. Canon laws means the Christian laws are called as canon laws. Muslim law is called as Sharia law. Okay, so we'll check for the religious laws, what it says, and based on that, they'll be deciding which is essential integral part of the religion or not. You may be asking, sir, won't there be bias? Yes, of course. Okay, but ultimately we believe in judiciary. Okay, we think that whatever judiciary is doing is fine. Okay. In Gujarat, there is a Muslim community, Bogriya community. Okay, they involve in female genital mutilation. Okay, so the female sexual organ will be mutilated. Okay, at a given time. Okay, so that is their practice. Okay, so in order to have a healthier life for women, and there is some, even in dogs we do it, right? So if you don't want any puppies, pet dogs, they go for female genital mutilation. Okay, so that the dog lives for a longer period, and they are not subjected to certain issues, problems, cancer, uterine cancer and all will not come. So they demanded as a religious practice. Okay, now the court said that no, it is not a religious practice, we will not allow, because it is affecting the health of the individual. Okay, fine. Now, once again, we discussed about samtara, the practice of samtara. That is allowed because they feel in samtara, in Jainism, achieving moksha is the essentially integral part of religion. So samtara practice is allowed. Okay, Muslims and Hindus, okay, for their pilgrimage, no, government is giving subsidy. Okay, it was giving subsidy, but for Christians, there's no such subsidy, because for Christians, pilgrimage is not a essential. But for Hindus and Muslims, it is essentially integral part of religion. Muslims, one of the 5 duties, they have to go to Mecca once in their lifetime. That is the final duty they have to perform. For Hindus, no, they have four stages of life and four goals in life. Right? Can anybody tell me what is that? Oh, good. I have a additional information from Gobi Jagan. Okay, Gobi Jagan is saying that the female genital mutilation is not only among the Muslims, it is prevailing among some of the Hindus in the North India as also. Okay, maybe we can discuss after class, Gobi. You can give me some extra information related to that, because you have made a presentation on that, no? So I think you'll be able to give me more information. Good. Okay, and see, Aram Porul Inbam Vide is Tamil literature. I'm asking about Hindu philosophy. What are the four? Very good. Brahmacharya, Grahastha, Vanaprastha, and Sannyasa. Okay, Grahastha and Sannyasa. Now, what is this Sannyasa? Vanaprastha is Brahmacharya means, young age, it should be dedicated for education. Okay, then it comes for Grahastha, that is household. Okay, then Vanaprastha is you have to go to the forest and live there, so that you allow the younger generation to take care of the society. And sannyasa is you have to visit Kasi, Rameshwaram, like this, important places. Okay, so the one of the four goals, okay, for in the one of the stages of life, you have to go for pilgrim places. It is a fundamental duty of a Hindu. Likewise, four goals is Artha, Kama, okay, Dharma, and Moksha are the four goals that should be achieved by a Hindu. Okay, I think some of the Hindus now only are knowing what are the goals of Hindu life, right? Okay. Okay. So, based on the Hindu philosophy, there also the ultimate one of the goals is to have pilgrimage. So, it is essentially integral part. So, state is supporting, state is giving subsidy. Okay, fine, done. Now, third point is propagation. Okay, so when you say that we have the right to propagate, it means if you feel your religion is good religion, the religion will help others, you go and satisfy the needs of others. Propagation means spreading your religion, but right to propagate does not mean right to conversion. You cannot convert others to your religion. Okay, so that is why anti-forceful conversion law is there. But remember, according to Article 25, according to freedom of conscience, you can voluntarily convert. If you personally feel in your heart that that other religion is good for me, you can change the religion. But just because you get job, just because you are getting education, you are getting money, or you are being threatened, okay, you cannot convert your religion. Okay, so people cannot induce or threat other people to convert to their religion. They cannot claim it as a right. Okay, so voluntary conversions are allowed under Article 25. Forceful conversions are not allowed. Okay. So when you ask, the recent laws, okay, anti-conversion laws of UP and Madhya Pradesh, okay, uh, as long as it is anti-forceful conversion law, it's not a problem. Anti-forceful conversion laws have already been there in many states. Now, why is such a hue and cry over UP and MP's law? Because they are targeted Muslim men, okay, and it is gender biased. Now, if you read the law, no, if a woman is converting to other religion for marriage, the husband will be punished. But if the husband is converting, okay, if a male is converting to other religion for marriage, no punishment. Okay, so it is like the entire law is talking about purity. Okay, thinking that is a women should see only when you think women as a commodity, you'll be so possessive. Okay, women from your family or caste or religion is married to some other guy, you will be angry. Okay, so such commodification and patriarchal thinking, yesterday's essay question. Okay, patriarchy is not sensible. Okay, it's not visible directly in the society, but it is a very important factor which is preventing social justice. Okay, this patriarchy is structure. So patriarchy and social justice, on that you have to write an essay. Okay. So subtly, the law is telling that women is like a property. So if women is converted into another religion, will be attacking, will be punished. And moreover, there is specifically mentioned, okay, if the conversion is there, the punishment will be up to 10 years. The other case where the punishment is up to 10 years is murder. Okay, are we treating conversion equal to murder? Then that is also the issues there. Okay, so the intensity of it and the timing of it and in the background on which it is being done. Okay, so yesterday suddenly one person told me in Andhra Pradesh lot of conversion is taking place. They have vandalized around 600 temples and they have installed cross in there. I've asked where is the news? Where is the data? You're exactly trading 600 temples. Give me the location, give me the data. Give me at least one source which shows that. Okay, so like that only UP, Love Jihad, there is a data given. Okay, I think 3 days before, there was an article in Hindu newspaper, don't write hate into the law. Okay, person has written, she has mentioned that interreligious marriage, out of the total marriages is taking place, interreligious marriage, 2.5%. Very good, very good. That's good, Vinisha. You were reading newspaper. Okay, this is 2.5%. And that is interreligious marriage, not that between Hindus and Muslims alone. Okay, Hindus, Muslims, Christians, Jain, Parsi, Buddhist. Okay, if you take all the religions, no. So when interreligious marriage itself is less than 2.5% of the total marriages, where is the case of love jihad here? So we must know data, have data, no, in the hand. Supposing if the number of Muslim women marrying, sorry, a Hindu woman marrying a Muslim man is increased by 10 times, 15 times like that, okay, there is something alarming is taking place. We can say love jihad has taken place. Now this percentages remained same, constant, and the numbers is also few. Out of every 100 marriages, 2 or 3 marriages is interreligious marriage. One marriage. Then where is the case of love jihad here? Where is the people converting? No? Like one person told, no, UPSC jihad. More number of Muslims are clearing civil services. Okay, just to Islamize our country. If you take the total percentage of Muslims in bureaucracy, they are less than 2%. What is their population? Their population is 14%. Now I think 15%. 15% population is only represented less than 2%. You call UPSC jihad. You must talk with data, right? So likewise, women also, in case of anti-conversion law, there is no data, but they are targeting love jihad alone. Okay, which means it's targeted Muslims. That is why the civil society is feeling bad about the law. Okay. See, of course, yes, temples have been vandalized by Mughal rulers. Yes. But our people will say lakhs of temples has been vandalized and all the money has been taken by them. It's true. Okay. But you should not put additional thing, no, in order to increase the hatred. Okay, that is not appropriate. Now, I was telling about this, no, this essay, patriarchy essay and social justice. Okay, I'll give you one example what they're asking there. Okay, my son was watching one of the rhymes, Tamil rhymes. Okay, dosai amma dosai. Okay, in that rhyme, no, for the male child, 3 dosas, for the female child, 2 dosas. This is what, patriarchy is not visible directly, but it is deeply ingrained in the minds of people. So women are given less opportunities. Okay. So even while giving opinion in family related, we'll be seeing only the male will be doing the talking. Female cannot talk in public. Okay, in the main family discussion. Nowadays things have changed. Okay, so women only do the talking. Okay, men has to be silent now. So the point is, anti-conversion law structurally it reflects the patriarchal society. Okay, so that is the result. That is the reason why it has been agitated. Okay, fine. Now, anti-forceful conversion law is bad, but anti-conversion law is constitutional. Anti-forceful conversion law is constitutional. Okay, fine. Any doubts in this? Okay. So we have done with Article 25. Okay. So we will go for the break, 15 minutes break. Okay. And 4:15 let's come and then discuss the remaining articles. Okay. If you have any doubts in Article 25, I'll discuss it at that time. Okay. Thank you. Okay, let's start the discussion. Okay, so yeah, Article 25. Any doubts is there? Okay, so we can profess, practice, and propagate religion not only in our place of worship but also public. Okay, so that is the essence of Article 25. Article 25 is subordinate to other articles. Any questions? Yes, Gobi, can you click on the hand raise button and brief me on your presentation, female genital mutilization? Is it possible to do now? No, it's not there, it seems. Okay. Okay, then Article 26. Okay, Jagan. Okay, I got your message. Article 26 talks about the rights of the religion to manage its own affairs. Right of the religious denomination to manage the religious affairs. See here, they have used the word religious denomination, meaning not only religion but also the sects of the religion. Sect of the religion. Okay, so within Christianity, multiple sects are there. Within Islam, within Hinduism, different. So every group, okay, has a right to manage its own affairs. There shall be no intervention from the state, and there shall be no intervention from one institution to the other. Now, religious denominations. What is the difference between Article 25 and 26? Article 25 is individual right. Article 26 is group right. Article 26 is group right. Okay. Now, religion denominations have the right to establish religious and charitable institutions. What is religious institutions? For example, Hindus, they can establish ashrams. Buddhists can establish monasteries. Okay, Christians can establish their own religious orders, like priesthood, nun. There are different groups. Okay, so religious institutions can be established. Is their right? No intervention. Charitable institutions like orphanage, school, college, hospitals. Okay, that can be built by the religious denominations. Okay, so religious denomination can be established religious and charitable institutions. Then second is whether the government can interfere in religious activities. So for that, there are two types of activities: core religious activity, and then activities related to or secular activities related to religion. A religious denomination can establish religious and charitable institutions, core religious activity and secular activities related to religion. What do you mean by core religious activity? Or what time the puja should be conducted? What is the agamas that should be followed? Uh, when is Ramzan should be celebrated? What are the scriptures that should be read in a particular day's service? Like that, each religion has their own religious rituals. The core decisions related to that is taken by the religious leaders themselves. In core religious activity, no intervention from the state. Core religious activity, no intervention at all. So Article 25 says that, okay, just to bring equality within the Hindu religion, Hindu religious institutions alone will be open for all the sections within the religion. Hindu religious institutions, like, priesthood, the temple and all, will be open for all. Okay. Now you may be saying, sir, who has to preside over the session? Who has to preside over, okay, doing the pujas and other things? According to Agamas, Brahmins only should do. Okay. But, now governments across the country, they are creating laws to give access to all the castes. They are giving training to many people, okay, and they're saying that you also can become a priest. Okay, now how it is possible? Because core religious activity, no intervention, but in order to bring equality within Hinduism, Hindu religious institutions can be open for all sections. That is, all sections within Hinduism, not for other religions. As we have discussed, supposing a Hindu temple says that Muslims cannot enter into that temple, it is not violation of constitution. Or a Muslim saying that people belonging to other religion should not enter into their mosque, that is not a violation. Okay, but within Hinduism, if they are saying that Dalits cannot enter, women should not enter, that is a violation of constitution. Because Article 15, Class 2 says so. Okay. But secular activities, what is secular here? Here, when I say secular, which is non-religious activity. Secular activities here means non-religious activity. For example, administration. If you go to Tirupati Devasthanam, transport facility has to be provided, toilet facilities has to be provided, food, accommodation. Okay, so these basic facilities has to be provided. So these are secular activities related to religion. That is a huge task. It can be performed either by the people who are taking care of the temple or government can assist. In core religious activity, government cannot interfere, but in secular activities related to religion, administrative activities, government can assist. Or government itself can take whole administration in case if there is no persons. Okay, secular activities related to religion, in case there is no administration is there. Supposing there is a temple and the temple is abandoned by the caretaker, government can interfere. Or those who are taking care of the temple or the mosque or the church becomes corrupt. then also the government can interfere, take over that administration. But in the first case, the takeover is permanent. That is, when there is no administration, if the government is taking care of the administration, it is permanent. Okay. If they're going to take it because of corruption, it should be temporary, which means the government should make necessary changes in the administration and give back the administration to the same people, the parties. Okay. Government cannot retain the administration for a longer period of time because the logic is only when there is no administration, you have to take care of the administration. You cannot take the right of administration from the religious people, even for secular activities, from the religious denomination. Okay. Now you may be having a question, sir. Only Hindu temples are taken care by the government. We have a separate department for that. But for Christians and Muslims, it is not like that. Why is it so? See, Hinduism is a decentralized religion, meaning there is no connection between one temple and the other. If a temple is administered by a group of people, they don't have connection with the other temple. So if one person is, the person who's in charge of the temple is abandoning the temple, replacement will not come. But in case of churches and mosques, they have a centralized system. They train a group of people to take care of the churches. Now, whenever there is a crisis situation, okay, whenever there is a problem, or whenever the administration of the church and mosque is not there, another person will be replaced for administration. So Christianity and Islam is centralized religion, but Hinduism is a decentralized religion. That is the reason why whenever there is an abandonment of a temple, immediately the government has to take care of it. Remember, in case if church and mosque also same thing is happening, the government can take care of it. Okay, the government can take over the administration. Okay, Juma Masjid. Okay, government is taking care of its monumental protection. It takes care of the infrastructure protection. Okay, whenever some churches are renovated, the government funds, okay, in order to renovate the churches. So it depends upon the government. Okay, now in case of Padmanabha Swami temple in Trivandrum recently, okay, the court has once again told that if there is a traditional people who are taking care of the temple, the administration should be left with them. You cannot take the administration by yourself because the Kerala High Court, sorry, the Kerala government, they took over the administration of Padmanabha Swami temple in Trivandrum. Okay, it was under the administration of the Rajas. Okay, so it was a princely state, a Raja was there. The Raja is taking care of the. Now, when Kerala government took over the administration, they went to the Court of Law and Supreme Court clarified, since there is a traditional people to take care of the temple, give back the administration to them. You cannot interfere. Okay. So in Chidambaram temple case also, Tamil Nadu government took over the administration of Chidambaram temple. The Madras High Court gave a judgment to give back the administration to Chidambaram temple. Why they have given the thing? Because traditionally Dikshitas are there to take care of the temple. Okay. So that's fine. Secular activities related to religion. Now, what about the property? What about the property of an individual. See, property is a very essential thing. Corona times would have made you realize this. Okay, those who had property, okay, so even though jobs are lost, even though incomes are reduced, they are able to sustain, okay, with the help of the savings that they had. Property. So think about, ordinary people, they are suffering, very much suffering. Okay, so those who worked with me and all, the manual workers, cleaners and all, domestic workers, virtually they cry whenever they speak to me, okay, because, they don't have alternate livelihood because property is not there. So property is essential for survival of a family. Likewise, property is also essential for the survival of religion. Okay, see, popular temples, popular churches, mosques, they'll get a lot of donations, no problem. What if suddenly devotees are not giving any donations? How will the temple will run? How the church will run? How the mosque will run? So they must, have property. So that is why Article 26 gives rights for the religious denominations to acquire and maintain the property. And acquire means you can buy property and maintain the same. So even in the lean seasons, when the religious place of worship is not getting any donation, support from the public, it can still sustain. Even now we have seen many of the temple. They'll build a temple around the temple. They will locate a land. Okay, the land will be any establishment in that land. Rental has to be paid to the temple. Okay. Now, when you say you can acquire the religious property, okay, of the temple, whether the government can acquire, government can take away the property of the place of worship for public purpose. Come on, anyone answer me? Whether government can take land or acquire property from the religious place of worship, church, temple, mosque. Yes, very good. Okay. The government can acquire, but there are two types of property: immovable property and movable property. Immovable property means land, buildings, etc. Movable property means cash and jewelry. Immovable property can be acquired by the state, but movable property, cash and jewelry, cannot be taken by the state from the religious place. Otherwise, whatever donation you are making to the temples, government will take. Okay. What is the purpose of Article 25 to 28? You have to sustain religion. To sustain religion, you need property. Okay. So whatever money that is given, okay, to you. So if you allow the government to take money or gold, the government may take away all the savings of that particular place of worship. Now tomorrow, if the same place of worship is suffering from financial requirement, government may not supply with it. Okay, for example, Tirupati, they say Tirupati collects lakhs and lakhs of rupee every day. And whether this money can be taken and used for the welfare of Andhra Pradesh, no, it cannot be. If that is the situation, okay, Andhra Pradesh government need not worry. They need not, even demand the central government's grant, but they are asking for special grant from the central government continuously. Okay. So if they need money, they could have taken directly from the Tirupati Devasthanam, but they are not taking because they cannot take it. So immovable property can be acquired, okay, and compensation shall be given by the state. Movable property can never be taken. That is why the gold that is there in the uh, Padmanabha Swami temple in Kerala, Trivandrum. Lot of gold is available there. Okay, lot of gold, not just very limited, a lot of gold. And whether the government can take this gold, they are saying that uh, if the government takes the gold from this place, they can sort out the problem of gold import. India need not import the gold itself. Okay, 90. See, even if you take 95% of the gold from Padmanabha Swami temple, the remaining 5% itself is suffice for the temple to function for another 2000 years. That much gold and wealth they are having. Okay, fine. So now, you're saying whether can we take this gold to the country? Economically also it is not proper. Okay, it's not appropriate. Okay, economy also it is not appropriate. Constitutionally also you cannot do that. If we now allow the government to take gold and money from that temple, then the government will take money from churches, temples, mosques, everywhere. So in future, they will not allow the religions to sustain. That is why movable property cannot be acquired by the government. Okay. Now, what will be the compensation? The compensation shall be decided by the government. There is no strict rule for that. Whenever government acquires the property of a religious institution, the compensation will be decided by the government. But government has to ensure continuous functioning of the religion. Now, another important question: can religious place of worship destructed for public purpose, a mosque or a temple or a church, can it be destructed for the public purpose? Okay, fine. So religious denominations can establish religion and charitable institutions. Yes. Okay, mosque, church, and temples can be destructed for public purpose because our people are very smart. Okay, suppose you have a small land, you want to encroach the land in front of you. What you do is build a temple in the corner of the land. Okay. Now, if you can use the land, okay, as long as possible. Suddenly, if the government is coming and it's saying that it's an encroachment, I'm going to remove. You go and gather all your neighbors and say that government is coming to destruct the temple. Okay. Now, what happens? It's a sensitive matter. Government will think twice. Okay, then they'll have to file a case in the court of law, and things will be prolonged. Directly, government is coming and touching, then politically it will backfire. Okay, the entire state will say this particular government, if ADMK government is there in the power, ADMK government destructed temple, destructed church, destructed mosque. Like that, they make it as a political issue. Okay. So that is why once this has happened in North India, the court has said the district collectors themselves can remove the place of worship if it is in the encroachment land. For public purpose, you can do it. Okay. So it can be restricted, not a problem. Even it may be a temple land, a church land, a mosque land. If for public purpose, you want to restrict it to enlarge. For example, there was a church on the roadside. The road has to be expanded. If the road has to be expanded, some front part of the church has to be restricted. Okay, so they asked whether you are going to minimize the size of the church. The church authority said no. But the judiciary said, okay, the church shall be restricted for expansion of the road, provided the people in that church is not stopped from practicing their religion, which means until and unless alternative place is allocated and a new church is built, this church shall not be restricted. Okay. So the purpose of all these protections is you have to allow the religions to continuously function. Okay. So if that happens, acquisition of property is not a big problem. Okay. So Article 26 also has some reasonable restrictions. Okay. Security, public order, morality. Security, public order, morality. Yes. Why are you not today? You are not asking any doubts. Okay, Mageshwar. Okay, you are saying that after 1992 Babri Masjid demolition, Supreme Court said that any further place of worship should not be altered or destroyed. Is it not violating? See, they have very clearly mentioned this. For public purpose, you can do. Okay, but if in the claim that you're going to build a temple, you're going to destruct a mosque, or to build a church, you're going to destruct a temple. Okay, if that is happening, then we can say it is wrong. So the Protection of Places of Worship Act that was brought by the Parliament, and it once again, the judiciary in the recent Ayodhya case judgment also has reiterated that Babri Masjid issue will be the last issue. So hereafter, it should not be an issue. Okay, because the right-wing forces, they're aiming on other places, Madura also. Okay, place Madura, they want to rebuild the temple there instead of the mosque. So now, they wanted to further, don't want to, escalate the problem. So they said hereafter, you cannot touch a mosque or a church or a temple, destroy it in order to create another place of worship. Okay. So in case if somebody is distracting and demanding that we want to create another place of worship, not be agreed, and the previous place of worship will be restored. Okay. Having experienced a bad thing, earlier, now we have this law. Okay, but for public purpose, if you're acquiring the public land or small part is done away with, it is not a violation of law. See, Devaswanam boards, is managing the property of the temple. They're not taking away with them. Okay, for example, what they will do is they will invest the money in the bank and will manage the bank and use it for the administration of the temple. So Devaswanam board, even though offices are there, okay, we have offices, government offices are there, that money cannot be used for government purposes. It is managed by them there itself. Okay, can temple administration people give temple movable property as loan? Yes, it can be done, but they cannot lend it to the private sector. Okay, instead of that, they have to keep it in a secured place, right? So they prefer banks. Okay, so they'll invest in the bank and get the returns. Okay, so people are asking, sir, then huge money is there. What will be they doing with that money? So that is why it comes into the economy. Like if you are investment pumping that money into the bank, okay, so the temple will keep on getting the interest. It's property will be accumulated, but the money that is inside the bank can be distributed as loans. Okay, so the banking system helps the money given to the temple is rotated back into the economy. Okay, while temple also does not lose its property, at the same time the society is also benefited. They can give for example, if the temples feel there is a natural disaster, they have to give some money to the government. Okay, they can give it as a donation. Part of it, okay, can be donated, but that should be taken as a resolution in the board, not by, it should not be decision of one individual, but decision of a group of people, the board. Yeah, managing the religious affair. Okay, in managing the religious affair is you are allowed to establish institutions, right? What if you are establishing a religious order which involves in black magic, okay, or some satanic way of worships, okay, or in the name of religion you are involving in homosexuality or some other unnatural sex. So in these circumstances it will be against the public order and morality. Can the temple start a gold selling business with all its resources? See, when money is there enough for the running of a temple and all, no, you no need to sell gold. See, property is there, it can be solved only when there is a desperate situation. So in case if there is a desperate situation, then the board will decide to sell its assets in order to fund. Otherwise, people will ask question. And remember, people themselves can ask up for accounts to the temple authorities, church authorities, mosque authorities. If they find any corruption or any of the bad thing, they can file a case in the court of law. So administration itself can be taken from the okay, the administration. Who funds the construction of new temples? Okay, so they'll be establishing a fund. Okay, people only. Okay, people give money. For example, the Ram Mandir, no, it's a be constructed. Okay, various organizations and various people's group, they are funding it. Okay, so donations only. Once again, new temples are built by donations. Already established temple is there, mosque is there, church is there. If it is to be renovated, there is no money, government will give money. Okay, but fresh construction of temples, government will not be giving money. So what Nityananda is doing is against public order, right, sir? Okay, first you must prove whether he is doing something wrong. Okay, and to prove that, you must find where is Kailasha is located. Okay, which country is in which country? He is now the president of Kailasha. You cannot arrest a president of another country. You're sure it is Ecuador? People reports that it is Ecuador. Some people are saying that he's in Bangalore only in some undisclosed location, and he's saying that he's in Kailasha. Yeah, okay, fine. Okay. So I was just Googling it. Okay, fine. The Google also says the same thing. Okay, off the coast of Ecuador. Okay, fine. Okay. So in case if it is proved that if some of the that is why public order and morality has to be defined by law. Okay, and if it is denied by him, and of course, okay, it can be considered as a wrong thing. It can be restricted. Is very intelligent. Okay. See, they are smart people. Now, how many of you think? Suppose you want to own a land, what you have to do? Anybody? You want to own a land? Okay. What do you have to do? You will say that, sir, I have to earn money, and that with money I buy the land. Yes, but I'll give you one idea. Okay, find out a place. Okay, where there is no people. Okay, no, usage. Okay, some vast land, but some water resources are there. Okay, go and build a small home to yourself. Okay, or make a boundary, build a boundary wall, and take your family there. Start do the farming there, rear the cattle, live there. Until government is seeing you, no problem. Forest area you cannot do, but there are many land area, okay, which is not a forest, okay, which you can go and just locate and you can live. Okay. So the idea of land as a property, country, nation, and all is created by human beings. So our mind is set. Okay, Nityananda is a big thinker. He knows, okay, that he himself can create a country if he is able to buy an island. Yes, he has did it. Is there any law to restrict such encroachment? See, all land which is not owned by any individual, not registered in any one name, is belonging to the government. Okay, so government can come and remove you, but when government will come? Only when there is some resources. Okay, when they find some iron ore or some deposits in that land. Otherwise, why would and how would the government will watch that? Okay, you can live peacefully. Okay, no issues until the government comes there for some development project or construction activity. Okay, when the government they comes there, you can shift to another place. Simple. Okay, nomadic tribes are like that only. You find them. They just go there wherever the land is there. They put their tent and live happily. Some point of time, the authorities coming and saying you must not be here. You must relocate. You must go somewhere else. They remove all the tent and go and locate themselves in some other place. Continue to thrive even without purchasing land. Okay, so just give me a second. 1 second. 1 second. Give me a second. Okay, fine. I'm back. Yeah, that is there. That's one of your saying, no? See, uh, government is by human beings, right? So if there is an RI and VAO, the it is the job of the revenue inspector to constantly keep checking whether there is encroachments or not. But revenue inspector will be busy in other duties, also a lot of work, no? So slowly people, encroach upon a land. Okay, so they'll be, running it for years. Supposing one RI is going and asking, how come we are constructing it? Okay, simply they'll give money to the RI and, send him back. Now, if somebody has to report and ask for the original documents, then only they'll be caught. And it is a civil act only. Encroachment is a civil wrong. So what the government will do is you have to remove from that place. Okay. So simply they will abandon that place and go. That's all. Okay. But by the time this is happening, they could have, do it for a longer period of time. Sometimes fake pattas are arranged and even they sell the land to others. Okay. So this is why, you must be very cautious. You must cross check with the uh, Tahsildar office or registrar office, whether the land is belonging to the government or belonging to that individual. Okay, so at least you have to trace the ownership for the past 100 years. Okay, if not for 50 years. Okay, then only you should buy land. Okay. Okay, this is done. Okay, so Article 27. Now, Article 26 is done. Now we said that government cannot take money from the uh, temples. Can government tax the religious denominations? Okay. Article 27 says that no tax for the promotion of religion. No tax for the promotion of religion. Okay, so please give me 2 minutes. No, there is some disturbance that is going on. I'll clear that and come. Okay, just 2 minutes. Okay. Okay. Let's start. Okay. So there shall be no tax for the promotion of religion, meaning the government cannot collect tax for practice of religion, promotion of religion. In India, we had a system called as jizya under the Mughal rule. Non-Muslims has to pay the tax, okay, for practice of their respective religion. Okay, so it is a tool to make people to convert to Islam, because poor people, you know, instead of paying tax, they'll convert to Islam. Okay, so such kind of tax should not be collected. So tax will not be collected from any individual or from that matter religious denomination for the state. There's no collection of tax. But tax money collected from you and me can be utilized for the religious purpose. For example, government is giving security, government is providing subsidies for pilgrimages and all. Okay, so where does the money come from? The money comes from the public. So the tax that you and I pay, okay, shall be used for the religious purposes. But it should not be used for one religion, it should be used for all the religions equally. If the government is using it for one religion, then it is violation of the constitution. Okay. Now, very important, fee, okay, can be collected, but not tax. Fee can be collected, not tax. What is fee? Fee is the amount that you collect, okay, from the people to use it in the same place. Okay. If you are collecting fee, okay, to be using it in the same place of worship. For example, you go to Tirupati, there, you know, darshan tickets are sold. To have darshan, no, tickets are sold. So these tickets, is nothing but fees collected in order to carry over the administration in that place of worship. Okay, so fees can be collected, tax cannot be collected. This is Article 27. Now, Article 28. Should there be religious instruction or not in the schools and colleges? Okay, that is the question. Okay. So what's the religion as per constitution? See, constitution has not defined religion, but Supreme Court has defined religion. Okay. So will a tribal religion or a cult can even be considered as a religion? Yes, they can be. Okay. So far, you know, the government has not interfered in the tribal religion. Or tribal religions, they have not come to the court of law. But if they want to be, they can. Okay, so the Supreme Court has defined religion as a group of people who have similar beliefs and a constant set of practices distinct from others. Okay, so tribal religion, okay, can be treated as a religion. Religious instruction. Religious instruction in educational institutions. Okay. Now I told you already what type of secularism Indian secularism is. Is it positive or negative? Please answer. Positive secularism. Indian secularism is positive. Okay. Meaning the state will act in positive, negative means in polity. I told you positive means there is action of the state. Negative means the absence of action of the state. Okay. So Indian secularism is positive because it is the state will act, interfere in religion. The state will facilitate religion also. The other countries know they don't worry whether the religion is protected or not, whether religion lives or then it's up to the society. But in case of India, okay, the government will protect the religion, facilitate the religion, promote the religion. Now tell me, in that case, whether government should give religious instruction in education institutions or not. And before that, before asking this question, I just want to also clarify what is the purpose of education, you tell me. Let me see. To gain knowledge. What is the purpose of education? I am asking a question. What is the purpose of education? To understand our surroundings, good, induce the human mind to think. Okay, you're being like UPSC. Okay. There is a life is a long journey between human being and being human. Yesterday essay topic. Okay, where from they are getting these topics, I don't know. I think they would be taking questions when they're high, okay, and taking some drug or liquor. Okay. To get conscience, good. To develop his her way of life, good. Enhance your skills. I agree. Contribute to nation building, good. All these are functions of education, good. Okay. For society, this is for individual. Okay, these are saying you are for individual. What is the benefit you are saying? Good. For society, what is the benefit of education for the entire society? What benefit that education is giving for this entire society? Individually, you are getting conscience, you are literate. Is okay. See, education transfers the knowledge from one generation to another generation. So the new generation can start from the higher level instead of starting from zero. What if knowledge is not transferred from one generation to another generation? Every generation has to start researching about a particular thing. That is why books, we store knowledge in books. Okay, so that the coming generation does not repeat the same mistake. See, the greatest civilizations, right? Okay, they will always be documented civilizations. See, Bible or Quran or Bhagavad Gita or any other scriptures, they're all documentations of human history. In some point of human history, civilization, some problem would have occurred. Okay, so they've recorded that as moral stories, so that the future people can need not repeat them. Once again, yesterday's question, okay, essay question. What we are is the culture. What we have is civilization. What we are is culture. What we have is civilization. Okay, so civilization is the record of the past. Whatever knowledge people have acquired, they've gathered it. They're transferring from one generation to another generation. So other generation does not repeat the mistake. It increases the knowledge further. So that is how human beings progress, society progress. So the utility of education is transformation of knowledge so as to sustain the society, progress the society. Society will not decline. See, the English medicine, no, is very popular and is successful. But Indian medicine system, Ayurveda, Unani, Siddha is not popular. Why? Please let me know. Why? Quick, quick cure. Yes. Okay, I agree. I agree that there is quick cure because if something is peaking, no, recently only the Indian government has allowed even the those who are practicing Ayurveda can go for surgery. Okay, surgery is one biggest thing. Okay, they have done because of that immediate intervention. Okay, if you are going to very serious condition, also you can be retrieved by giving. But medicine in Ayurveda, Siddha, and all is long term, preventive. The cure takes place, comparatively a little bit. And even then, no, there is scientific backing for Ayush. Okay, not enough marketing and supply chain for that. That is also true. Okay, fine. And mostly, whatever is Indian, we will not accept. Okay, Indians have that mentality. The reason why Ayurveda, Unani, Siddha, and all this, no, they were not documented properly. Very good. That's good, Mohammed. Most of them are transferred to the next generation orally. There are not so many written sources. And one more thing, one Siddha doctor will not, teach another Siddha doctor because they want to be independent, right? Okay, they until their death they only want to be unique. Everybody wants to come to that. So there'll be no sharing of knowledge. There will be no transformation of knowledge from one generation to other generation. Okay. Even orally, they'll transfer less only. Usually the Siddha practitioners and all, earlier and all, till their death, they will hold on to all the secrets of how the medicine should be prepared, what is the proportion. Only if they are aware that they are going to die, they'll call one of the disciple, trusted disciple, and transfer the knowledge. Okay, at that time, if they give some proportion wrongly, done. That's all. Okay, it's an issue. But anyway, they had memory power. Okay, that's why it's sustained. Despite of that fact, these systems are sustained because of extraordinary memory power of these people. Anyway, so that is the purpose of education. You transform knowledge. The success of English medicine is they document everything. Everything is open source. They teach, their juniors. Once my son was in hospital, I just watched and observed how they are doing the treatment. Okay, they consult with each other, and the senior doctor, while giving the treatment, will always have all the juniors, okay, explaining the case study, okay, and explaining, what had happened, how he has arrived at the diagnosis, everything. Okay, so that kind of knowledge transfer is not there. Okay, good. So now if religion has to be protected, if religion has to be continuously be there, what has to be done? The knowledge related to religion has to be transferred from one generation to another generation. Okay. If there is no transfer of knowledge, okay, then the religion would decline. Okay, there will be no practice of that religion. Okay. So now I don't teach religion to my son. So what happens is my mother, she ensures that every month she comes and stays with me at least for 3-4 days. All 3-4 days, okay, she'll be attending to my son, teaching all the religious philosophies. Okay. So she'll say that you only has become like this. Okay. And I'll not let my grandson to become like this. Okay, fine. Done. Okay. So the point is you have to transform knowledge from one generation to another in order to sustain the religion, in order to protect the religion. So now you tell me, I told you two things. One is India is a positively secular country. So it facilitates and protects all the religion. Second, I told you the utility of education. Okay, why religious education should be there? Because knowledge should be transferred from one generation to another generation. Like now, you tell me, in government schools and colleges, should there be religious instruction, religious education, government schools and colleges? Don't, don't answer from the constitution. Answer from the discussion that we had. I'm again saying answer from the discussion we had. Good, good. Archana, you are spot on. Government should provide education, religious education, because government should facilitate all religions, right? Okay, so to facilitate religions, government has to provide religious education. But as Archana has asked the question, there are so many religions. Which religion the government should protect? Which religious instruction government can give? It's very difficult, right? Okay, so we have small religions, and within religions also we have a lot of sects. Okay, it is a lot of sects. So each sect, for example, Vaishnavite, Shaivites, we have Shia Muslim, Sunni Muslim, Protestant, Roman Catholic. Okay, so like that. Now we have a lot of sects within the religion. Which sect values you will teach? It's highly complex, highly difficult. Logically, as a positively secular country, we have to protect all the religions. So we have to give religious education of all religions in this government schools and colleges. But that is not practicable. That is not feasible. That is why no religion, no religious education. Okay. See, when Rafael was inducted, or when we bought Rafael from France, our home minister took a religious priest along with him, and then they did the recited slogas and did the puja, and then they bought the Rafael. People in India started to criticize, telling that is why government is promoting only Hinduism. Then they had Rafael induction. The French defense minister came to India, and Rafael was inducted into Indian Army. Okay, at that time they called 3 religious persons, a Christian priest, mullah or Maulavi, and then a Hindu priest, and then they conducted prayers to induct. I would say that is also wrong, because do you think only major religion matters? No, there are minor religions also. What about Jains? What about Buddhists? What about Parsis? What about tribal religions? Okay, so when you are not able to facilitate all the religion, okay, don't facilitate any religion. Okay, this is the principle behind Article 28, saying government schools and colleges will not go for any religious education or religious worship also. Okay, fine. See, the logic is India is positively secular. So, when the government is holding it, it is not at all wrong. See, there was a question in another batch. Your batch is very silent. I don't know why. Okay, when I take religious class, all batches will be very excited. So one person was asking this question. The Prime Minister attended Ram Mandir foundation ceremony. Is it secular? Yes, it's secular. Why not? India is a positively secular country. Now, if the Prime Minister says, okay, when they're going to start the construction of a mosque also, no, in same Ayodhya. Supposing the construction committee is requesting the Prime Minister to come and lay the foundation for the mosque. Okay. And if the Prime Minister denies, it says that I will do it only for Hindu religion, I will not do it for the other religion. then it is unsecular. Okay. If the prime minister or the government officials attends a religious festival, it is not unsecular. Okay, because it is part and parcel. Okay. Or supposing you are going to start a government function, so you do it with a Bhumi Puja. Okay. Or you do some pujas, or you enter into a new government building, you're doing Ganpati Puja. So Ayuda Puja, you go to government offices, all the place, they'll have this decorations and other things. Okay, so is it wrong or it's unsecular? No, it is not. Only when you say you have to practice one religion at the cost of another religion. You can practice only one religion, you cannot practice another religion, there is a problem. See, even in Western countries, when the president of USA takes oath, January 20th, he's going to take oath, there'll be a short prayer ceremony. Okay. And after that prayer ceremony only, the president will take oath, and president will take oath on Bible and in the name of God. Okay. So in any country, for following a mainstream religion cannot be called as unsecular. Okay. Secularism is you are at equal level to all religions, which means when you promote one religion, you should also promote other religion. If you say that I wear all caps but not a Muslim cap, then it is unsecular. Okay. Anything I will do. Okay. I will go and have relationship with anybody. But if a person is a Muslim, I will not have a relationship. That is unsecular. Or a Muslim is saying that, I will have relationship only with Muslims, no other religion. Then it is unsecular. So secularism is not following your religion. I already told you, being religious is not unsecular. It's absolutely secular. But when you are being religious, you try to denigrate other religion, try to undermine another religion, that is unsecular. And that too because of that hate relationship. Yes. See, a prime minister is a prime minister. Okay. There's no leave for him. It's 24 hours is a prime minister. Okay. That is why when he is attending a religious puja, okay, he is attending as a representative of government of India. Okay. And moreover, okay, I should say that, president also should have attended the puja in Ram temple, Why president is not attended? Have you ever thought? When the prime minister is attending, why not the president? Because president is a Dalit. He's a scheduled caste. Okay, so he's not attending. Okay, so you must understand what is happening around us. Okay, and yes, in individual capacity, the prime minister can attend a puja, but he cannot represent as a state. Okay, but in this case, he is represented the Indian state. Okay, so when he is represented as Indian state, it's not a problem. What I'm saying is, it is absolutely secular, but provided you should also attend the other ceremony when invited for. Definitely Muslims will not invite. Okay, anyway, don't worry. Okay. If they are inviting in the capacity of prime minister, he cannot say that, no, I will go only for a inauguration of a Hindu temple. I will not go for this Muslim thing. Okay. If he says so, it is unsecular. So till now he has not said, so our prime minister is secular. Happy? Yeah, there is another thing. Shringeri Mat Puja for the foundation of new parliament. As we discussed, it may not violate secularism. And what Archana is asking is, won't it promote majoritarianism? That is what I'm trying to say. See, it has been a practice in India, for that matter, any country, okay, to have a mainstream religion ritual as part of their culture. Okay, part of their, because we are spiritual, we have some sentiments, we are human beings. Okay, so when we start, okay, we are doing it. Okay, so nothing wrong in it. Okay, it's not only now, even Congress governments do it. Okay, sometimes you enter into some government premises, you have a Hindu religious place of worship. Okay, only when you say I'll have only Hindu religious place of worship, we will not allow any other religious worship inside, then it's a problem. How many of you know what is the symbol of Tamil Nadu state? What if our prime minister belongs to another religion? Yes. See, Manmohan Singh, being a Sikh, he attended various Hindu religious festivals. He presided over. Okay, it's not a problem. And the prime minister is there. Okay, he has a choice, of course. Okay, but when he deliberately says that I will not attend a particular religious meet, then it is a violation of secularism. That is what I'm insisting. You can have preferences. Okay, so maybe there is a person, okay, who feels that, okay, in my personal capacity I have to go to my religious place of worship. For example, in many countries, for example in Kerala, Pinarayi Vijayan is a Christian. Okay, so whenever there is a mass, okay, Sunday mass, he goes and attends a church. Okay, but remember, he goes and sits as a normal person, not with police, not other, along with the people. He does not represent the state there. In individual capacity, you can have worship, not a problem. Okay. And the state capacity, when you're doing it, you have to go for everything. Very good. Now the question I asked, what is the symbol of Tamil Nadu government? Srivilluputur temple Gopuram. Very good. A temple is the symbol of state of Tamil Nadu. Okay. So if some of the North Indians are there in our batch, you will be very astonished. Okay, because Tamil Nadu is known as a atheist state, Periyarist state, and also, generally Tamil Nadu is portrayed as anti-Hindu. Okay, that we criticize Hindu gods and goddesses. Okay, but the state emblem of Tamil Nadu is a temple. And remember, it is in Tamil Nadu that temples are there for a longer period of time, 1,000 years, 1,200 years. Okay, and Tamil Nadu is called as a land of temples. Okay, here, there is no history of destruction of any temple, or for that matter, place of worship. Okay, except for the Jainas, no. Okay, so Jains were persecuted by Hindus, and some Jain temples were converted into Hindu temples. That was a minor, okay, historical event. Okay, but majorly, okay, it is peaceful, and a lot of temples is there. And of course, according to the Vaishnavite tradition, there are 108 important temples, like, just like they call it as, the path to heaven, Swargavasam, right? Okay, 108 paths to heavens are there. That is, important temples are there. In this, around 100 temples in Tamil Nadu. Okay. Okay. So whatever is listed in, in the ancient tradition, that is there. Okay, it's not destroyed. Okay, so such a tradition, okay, that Tamil Nadu is having. Now, nobody complains about that in Tamil Nadu, that our state symbol is Srivilluputur temple. A Muslim, a Christian, a Jain, a Buddhist in Tamil Nadu agree, because it is our culture. And it is a realization and maturity in Indian culture, in Tamil Nadu culture, that mainstream, religion will be part and parcel of everyday life. You cannot, say that no, you should not practice the majority religion. No, mainstream religion will be part and parcel of public life, provided it should not result in elimination of minority religion. It should not stop the minority religion from practicing. We will come to the religious instruction in private schools. Okay, but first government schools, this one. Okay, I think you are getting clarity now, slowly, right? Okay. See, if you read literature, how many of you like literature in this class? At least for namesake, you will like, right? Because you have pride in your language. Okay, so we'll say that I like my literature. Oh, good. If you read any literature, whether Malayalam literature, Tamil literature, Kannada literature, Pali literature, all the Hindi literature, all the regional literatures of India talks about Hindu gods and goddesses. There's very less literature about Muslim gods, Muslim Islamic versions, or there are very less the poem related to Christianity. So anybody who's reading literature, predominantly they'll read gods and goddesses only. Okay, they'll be reading about the Hindu god and goddesses. Can we say it is unsecular? No. It's part of language. It is part of literature. So it is true that in public life, in mainstream life, mainstream religion and language will be predominant. For example, Hindi. Okay, in morning optional class, people are saying, except in Tamil Nadu, all other states in India speak Hindi. Because Hindi is the mainstream language. Okay, even in Tamil Nadu, it would have come. But in Tamil Nadu specifically and purposefully, we have agitated against Hindi. That is why here people have not learned Hindi. But if you take other places and all, okay, slowly Hindi has grown because mainstream language will spread fast. You cannot complain. Like this, when the government is giving a name for self-reliance, Atmanirbhar, it is a pure Sanskritized Hindi. Ayushman Bharat, health for all, Hindi. Rashtra, Bima Yojana, Pradhan Mantri, Rozgar Yojana, or Gar Yojana. Okay, they're using the word Yojana, all Hindi. Okay, so automatically you will learn Hindi. Now you cannot come and complain that in the public life, only one language they are using it. Okay, while Hindi is also used, you should also give protection for Tamil. You have to give protection for Kannada. You have to give protection for Malayalam, right? That is how we demand, right? Likewise, in secularism also, there is a mainstream religion, okay, that will be part and parcel of regular culture. We cannot be complaining it as unsecular. What is unsecular is when you say we will promote majoritarianism at the cost of minority. Done. Now let us come to next set of schools, endowment schools. What do you mean by the endowment schools? Endowment schools are those schools which is established as a gift to the society by religious institutions. Endowments are gift to the society established by government. Okay. Now, you may be asking, sir, what is the example of endowment schools? Ramakrishna Mission schools and colleges is example for endowment schools. Ramakrishna Mission. Then DAV schools. Okay. Then convent schools and colleges, no? That is also endowment schools. Now, what do you mean by endowment? Entirely the expenditure of the money of the school's expenditure of the school is taken care by that religion. Government will not spend single paisa. Endowment schools are those schools in which government spends every paisa. Okay, no single paisa will be spent by the government. Now, whether religious instruction can be given in these places? Yes, 100% religious education can be given. Why? The reason why the religious institutions are funding these education institutions to spread their religious knowledge. Ramakrishna Mission wants to spread the ideas of Ramakrishna Paramahamsa and Vivekananda to the entire people. So if we want to spread a religious idea, we can establish an institution, call it as an endowment, and spread the religious idea. Now, I may ask, sir, what if Ramakrishna Mission, a Hindu or a Christian or a Muslim is joining? They know that the purpose of Ramakrishna Mission is to spread the values of Ramakrishna. So they are consenting already to take the values. So that is why in Ramakrishna schools and colleges, you will find they have to get up 4 o'clock in the morning. Okay, they have to recite slogas. Okay, and my friend, no, Chandru sir studied in Ramakrishna school. He will share all the experience there. Okay, you have to, take bath in a chill water. Okay, fine. You have to wear only dhoti and shirt. Okay, fine. So, of course, but discipline, even food habits and all, like you will be taught not to waste any food. Okay, so there is in these discipline related issues and is good in Ramakrishna schools. Okay, fine. Now the point is, in endowment schools, religious education can be given because that is the purpose it was established. What about private schools? Okay, private schools, if it is aided, okay, they have to give education voluntary basis. That is, you have to accept. The children should accept. The children cannot accept because they are minor, so parents should give the acceptance. Okay, now why voluntarily? See, what is the idea? Government is aiding, government is spending money. So government cannot spend money to promote one religion. Okay, so the private institution, if they're promoting one religion, they can promote one religion, but if aiding, the government is giving some aid, they cannot do so. Or they can spread their religion or give the religious instruction based on acceptance of the people. Okay, because otherwise government will be accused of promoting one religion. And we know India is a positive secular country. Whenever a private organization is trying to promote the religion, government will support. Say that, okay, you can do. But since I'm aiding, people should not come and complain that the government is aiding one religion. So you spread or give religious instruction based on acceptance of the individual. If a school is giving religious instruction without the permission of parents, or in college without the consent of the students, then it is violation of constitution. Then it is violation of their religious right. We can go to the court of law. Some Christian missionary institutions, yes, they do it. It is constitutionally invalid. Okay, you can very well file a case in the court of law. Then, what about schools which is getting recognition? Private schools. Now, we are seeing that under private section. Now, you may be asking, the government school also will be recognized. So, what is recognition? First of all, okay, when you study in that school, the certificate is valid in other places. You study in other school, no, the certificate is valid in other places. Okay. If the school or college is not recognized, okay, you go to a job, you go to some other place, the certificate is not going to be valid. It's a big problem. So now all government schools, endowment, aided schools, everything will get recognition. Now, when we say recognized schools, we are talking about private schools, which is not government school, which is not an endowment, the private school, and it's not getting aid. But if it is getting only recognition, the private school is getting recognition, then also it can spread education voluntarily only. Voluntary means they need the consent of the receiver of religious instruction, religious knowledge. Endowments means gift to the society. Okay, gift to the society. Okay, now people are asking, sir, what about Gurukuls, madrasa, Bible schools, and all? They are neither getting aid, they're neither getting recognition from the state. So they are free. Okay, we are not talking about government. They can give religious instruction, no problem. Okay, only when government funding is there, government recognition is there, we will be talking about whether there should be religious instruction or not. Okay, so in madrasas in other places, no need to worry. Okay, are you able to understand this? Okay, religious instruction. Article 29 is talking about 29 and 30. 28 is over. Any doubts? Any doubts? Okay, Article 29 is talking about 29 and 30 is talking about cultural and educational rights. Okay, 29 and 30 is talking about cultural and educational rights. And it is also called as protection of minorities. Articles for protection of minorities. Article 29 talks about any section of Indian citizen who is having any section of Indian citizen, okay, who is having any section of Indian citizen who is having distinct language, culture, okay, distinct language, culture, dialect, and script can protect the same. Any section of Indian citizen who is having distinct language, culture, dialect, and script can protect the same. Yes. So secularism is only about religion. Okay. Not about other things. Okay. So secularism mainly they talk about religion only in India. Does endowment schools are funded by state? No. Endowment schools is purely funded only by the religious institutions. Okay. So Ramakrishna Mission means Ramakrishna Mission only will spend, not the government. Maybe government teachers are there, but they also will be paid by the Ramakrishna Mission. Okay, fine. Now here, they have used the word any section of Indian citizen. Okay, any section of Indian citizen. Which means it is not only minority but also majority. Even though we started saying that it is protection of minorities, the court has explained that okay, it is both majority and minority. Even majorities have their culture distinct, their language is distinct. They have the right to protect the same. Okay. Now, section of Indian citizen, we mark this word citizen. They have not used the word person, which means this Article 29 is available only for citizens, not for foreigners. Available only for citizens, not for foreigners. So distinct language, culture, dialect, and script. Okay, language, culture, dialect, and script can protect the same. So language, culture, what is a dialect? Dialect is regional variation of the language. Dialect means regional variation of a language. Kannada is the language which has most number of dialects. Okay, that is because of it borders, multilingual states. Maharashtra, okay, Goa, this side, Andhra Pradesh, Tamil Nadu, Kerala. Okay, so they have the multiple, and of course, many northern empires have had control of the state of Karnataka in some point of time in history. So that explains, why the dialectics. Okay, there large number of dialects is available in the language of Kannada. Okay, and script also. Script means the written format of language is called a script. Okay, it can be protected by the people. So according to this article, the court has explained if the people are involving in any act to protect their language, culture, dialect or script, that will not be unconstitutional. That will not be violation of constitution. They have every right to do that. So this is Article 29, Class 1. Article 29. Class 2. It says that, okay, there shall be no discrimination in admission to educational institution. There shall be no discrimination in admission to educational institutions on the basis of race, religion, caste, language. See, race, religion, caste, language. In Article 23, it was race, religion, caste, and class. Here, race, religion, caste, language. Okay, so based on class, which means based on economical criteria, they can give admission or not. You cannot go and say that you are not giving admission to the poor people. No, you cannot say that. Based on gender, boys only college, girls only college. Okay, so you cannot go and say that you must have a co-ed education only. Okay, so that is possible. But when I say educational institution, okay, state funded, you can apply that it's only in state. Now you may be asking, sir, can there be a private school which gives admission only to one religion? Can there be a private school which gives admission only to one caste? Yes. Preference can be given. You cannot discriminate. Private schools can give preference to their own community. But government cannot discriminate based on race, religion, caste, language, because it is a public money. See, you are starting your school and you are giving education to your own community. It is your right. But when government is starting an education institution, it cannot deny admission based on race, religion, caste, and language. Okay, if state is discriminating, state is favoring one community over the other community. Okay, any doubts in this? Okay, so there shall be no discrimination admission to state-funded education institutions, race, religion, caste, language, etc. No, gender is not there. Okay, that is what I'm mentioning. Gender is not there. See, fees, when I say it's not poor people, the government may keep telling that this is the amount of fees. Okay, in government schools. If the person is not able to pay that fees, you can deny admission. That is the meaning. So class is not there. It's not that government will deny poor people the admission. They'll keep a money value. If a person is not able to pay, they can deny admission. That is the meaning. See, Article 15 is generic in nature, right? It talks about all the spheres. Article 29.2 talks about only educational sphere, that to admission in education. So Article 15 is generic in nature. Article 29.2 is specific in nature. Okay, so we can say 15 is larger canvas, 29.2 is smaller one. Like that we can say. No, not all government schools are free. Okay, who said government schools is free? Okay, the fees will be lesser in government schools. Now, reservation is in education institution is a preference, right? You're not discriminating. Preference is different from discriminating. Article 29.2 will not be violated if reservation is given. Any doubts? Okay, done, done. Okay, so we'll take the break, okay, and come back. 15 minutes break. Okay. So we'll take 20 minutes, okay, break. 20 minutes break we'll take and then come and discuss. Okay. Okay. So I thought this 25 to 29 dollar will go along. Okay, so we are doing it in time. Okay, I think we'll be requiring lesser time to complete than what I estimated. Good, fine. So 20 minutes we'll go for the break and come. Then we will discuss the remaining Article 30. Okay, thank you. Thank you. Okay, so let us continue. Article 30. Uh, okay, so Article 30, it talks about the rights of the minorities to establish educational institutions. Right of the minorities to establish and administer. Okay. Now, as I told you already, the mainstream institutions will naturally teach you the mainstream values, mainstream culture, mainstream religion, and language, as I discussed already. But minorities' values, okay, will not be reflected in the mainstream culture. So, as time goes, what happens is the minority culture will decline, minority language will decline, minority religion will decline because in schools, their religious related knowledge is not transmitted from one generation to another generation. For example, if a Tamil couple, okay, is settling in United States of America and a child C, a child is born, the child will not get an opportunity to learn Tamil. Okay, so it may speak Tamil, understand Tamil, but may not read and write. This child grows and then next generation child is born. That child, will know little Tamil only. The second generation child grows up and it gets married and the third generation child is born. That child will know that its origin is from Tamil Nadu, but it will not understand any words, okay, or not speak in Tamil. So when there is no mechanism for transformation of knowledge from one generation to another generation, and the schools do not teach the respective language or respective culture, automatically the culture and language and religion will decline. So that is why, okay, minorities are allowed to establish their education institutions so that in that institutions they can transform their religion related knowledge, language related knowledge to the next generation students or next generation community. Okay. So that is why minorities are allowed to establish their own education institutions and the state will support. Now, how the state will support? First is when minority education institution property is acquired. Minority education institutions property is acquired. The government will pay adequate compensation. Minority education institutions property is acquired. Adequate compensation will be provided. Now you may be asking, what is this adequate? Adequate compensation is the compensation that will help the minority education institution to continuously run. Or in other words, when government is acquiring the property of minority education institution for public purpose, it should not result in closing down of the institution. Okay, fine. Now just imagine that there is a minority education institution. Supposing there is a minority education institution. Okay, there is a road nearby. Okay, so the minority education institution is constructing a commercial complex. Okay, so let us assume that the minority education institution is functioning here. Okay, so the minority religion or language people, they are not having, okay, let us assume that they are not having enough financial resources to teach their children. The children is also not able to pay high fees. So the minority education institution is constructing a commercial complex at the end of the road. Now the government wants to expand the road. Okay, so they want to expand the road. Okay, so this part, okay, they want to acquire. Okay, so they want to dismantle the commercial complex. Now what happens? The source of income of the minority education institution is cut. The source of minority education institution is cut. So now government has to compensate in such a manner the income that was received by the minority education institution from the complex is continuously received. That amount should be given so that the education institution is not closed down. Okay, they have to give that much compensation. Supposing the government, there is another road this side. Okay, and they have to acquire a small piece of land where there is no building at all, only land is acquired. So in that case, the government can pay a minimal compensation, not a problem, because by acquiring that land, the functioning of the education institution is not going to be affected. Okay, so the compensation amount should be in such a way that the education institution continues to function, it does not stop. Now we may be wondering what is the relevance here. Okay, I come to that. There is a right to property, right? Earlier it was Article 31. Now it is shifted to 300. What is that? Right to property. What does right to property says? Okay, any citizen can acquire, manage, and dispose of property. Any citizen can acquire, manage, and dispose of property. Now, whether the citizen's property can be acquired by the state can acquire the property for public purpose, but compensation shall be paid to the citizen, which is determined by parliamentary law. Compensation is determined by parliamentary law. Say, let us assume that parliament is creating a law. Okay, and parliament says that the compensation for 1 acre land is only 10,000 rupees today. then whenever government is acquiring the individual property, the compensation will be only 1,000 rupees. Maybe low, but if parliament is deciding, that's all. If suppose parliament is deciding, the compensation amount will be higher than market value. For example, recent land acquisition act is saying, if land is acquired in the rural area, it is 4 times the market value. If land is acquired in the urban area, it is 2 times the market value. So now that compensation will be given. But in case of minority education institution, whatever the parliamentary law, the minority education institution's property, when it is acquired, it should be given adequate compensation. This is where the Article 30 is relevant. Parliament may increase the compensation, decrease the compensation. Even if parliament is decreasing the compensation, that will not affect the compensation of minority education institution. Because in the name of parliamentary law, the minority education institution should not be compensated less. The minority education institution, should not be in such a situation that it is closed down. Okay. Minority education institution cannot be closed down. Okay, fine. Now next is, we have to talk about the next provision in Article 30 itself. In Article 30, second provision is, whenever government is paying aid, no discrimination in giving aid. No discrimination in giving aid to minority education institution. Which means, if you are giving aid to any education institution, for example, the government is giving 5 crore rupee for a particular school, a normal school, private school, aided school. The government also should give 5 crore rupee to the minority education institution. Just because they are minority education institution, they cannot be denied the right. Why? Sometimes governments may hate the minority community and may cut the funding to the minority education institution. As a result, what may happen is they will not be able to continue. So supposing, let us assume there is a majority government continuously for 30 years. Definitely they will try to cut down the minority education institutions. So that is why Constitution is giving such protection, telling that adequate compensation has to be. If adequate compensation or aid is not given to the institution, the minority education institution can go to the court of law. Then third is regulation, whether minority education institutions can be regulated. Yes, okay, minority education institutions can be regulated if they are getting aid from the state or if they are seeking recognition. And next is, if not, both aid as well as recognition. So aid, recognition are both. Okay. That is how regulation is done. Now, those institutions, minority education institutions, which is neither seeking aid nor recognition, like madrasas, Bible schools, or Gurukul schools and all, where Vedas are taught, those schools regulation is not applicable. The government cannot regulate. But if the minority education is seeking aid or recognition, they might accept regulation. What kind of regulation? They must teach mainstream education also. Yeah, see, minority education institutions can teach their own religious related knowledge, language related knowledge, not a problem. But if they are taught only their religion related knowledge, what will happen? They will not mainstream. They cannot be nationalized. The minorities, while allowed to exercise their freedom, exercise their religious protection, must also be integrated with the mainstream society. So that is why mainstream knowledge also will be taught. Okay, so the literature, regional literatures, English, language paper, maths, science, social science, everything will be taught along with the religious education. So we will have a holistic citizen coming out of that schools. So this is the check the government is keeping over the minority education institution. Now, because of Article 30, any regulation, new regulations that is brought, except for the curriculum, all other regulations will not apply for the minority education institution. Will not apply. Curriculum, teacher-student ratio, quality of the school infrastructure, that all can be inspected, but other things cannot be done. Yes, or one of you asked who's a minority. Now I'll discuss. Okay, fine. I think clear, no? Article 30. Who is a minority? There are two types of minority in India. Okay, religious minority, linguistic minority. Okay, who is a religious minority? Religious minority is determined by the central government as well as state government. Okay, so throughout the country, okay, if the less number of people is there, okay, so they're recognized, in the national level as well as state level. So some states, for example, Punjab, Sikhs are not minority. Northeastern states, Christians are not minority. So each state will also decide who's a minority in that respective states. In case of Maharashtra, West Bengal, and Gujarat, okay, Jews are living there. So Jews are recognized as minorities. Okay. What is the criteria for a minority? Okay. So in other countries and all, they'll say whoever is least in number is a minority. But in India, okay, whichever group is social is requiring protection of culture. See, if they're not like SCs and STs, socially and educationally backward, because some of the minorities, if you take Christians, they are educationally advanced. If you take Parsis, they are both socially and educationally advanced. They are at the top level. Okay, you cannot call them as a minority. I mean, in the sense that least number. Okay, they are less in number, but then they require protection of culture. They require protection of culture because there is no scope that their culture can be propagated in India. How many of us know the Parsi culture? Not many of us. Okay, we know the fire temple. That's all. Other things and all we don't know. So in that case, okay, Parsis will be allowed to establish education institutions and transform their knowledge to the next generation students. Okay, so minority in India means those communities, those religious or linguistic groups which requires the protection. Okay, so this is protection of culture. There is no, just a second. Okay, so this is religious minority. Okay. Okay. Now linguistic minority, okay, is those who are recognized by each state. Okay, they're recognized by state. There is a condition to be recognized as linguistic minorities. Okay, they should be speaking, their language should be other than the state's official language. Language should be other than the state's official language. And their population should be less than 50% of the total population of the state. Less than 50%. Okay, which population? Population of that state. Population of that state. There is one question: can minority institutions deny admission to other sections of people, sir? No, it's not like that. Okay, so minority educational institution shall reserve seats for their own community up to 60%. Okay, remaining should be open to all. Minority educational institution can reserve seats to their own community up to 60%. Remaining is open to all. Any entrance examination like that, if it is happening, normally it is not applicable to the minority educational institution. But recently, in the NEET examination was introduced. So CMC, Christian Medical College of Vellore, they have filed a case in the court of law where they are not admitting students. They're telling that we should be free to give seats to our own students. Okay, that up to 60%. Okay, so actually by the constitution, any new regulations made by the state is not applicable to the minority education institution, especially related to admissions. Up to 60%, the state cannot interfere. Religious minorities is determined by both state as well as center. Linguistic minorities, no, it is determined only by state, not by the center. That is why see the uh, definition. No, language should be other than the state's official language, less than 50% of the population. Now, this rule is there because in case of Jammu and Kashmir, Kashmiri is the popular language, but Urdu is the official language, state official language, not Kashmiri. But Kashmiri people are more than 50% of the population. They cannot be called as linguistic minority. Okay, so the idea of linguistic minority is that they should speak the languages other than the state's official language and it should be less than 50% population. Okay, any doubts in this? Now that is why they want to file a review petition. See, according to my view, okay, so when you're conducting the examination, the government can stipulate that apart from the reserved seats, okay, the remaining seats they should be allowing in the government quota. Now, every minority education institution will be first asked, what is the number of seats you want to fill for your community? Up to 60%. So they can choose from 0 to 60 any percentage. Once they are fixed now, that amount of students only from that community, remaining should be open to all. So if government says that the remaining seats has to go to all, then the minority education institution should accept it. So then less than 50%. Okay, fine. Now, uh, see right now there is a case. Okay, NEET examination, whether it's applicable to minority education institution or not. There is a case in the Supreme Court. Okay, we'll have to wait for the results. Okay, whatever decision taken by them, no, they will be putting like this only. That is 60% of the seats you can fill according to your wish. Remaining 40 you should give to government quota. Then Article 32. Constitutional remedies. Now in India, okay, what is the structural problem is when the Britishers were there, most of the education institutions were run by Christian missionaries. One of you have asked, why would people want to join schools of other religion minorities even if they promote the religion? See, yeah, when the missionaries are running their institutions, they were teaching Christianity to their own community people. But for they have large number of seats. So government of India realized this, okay, and that until government is establishing a lot of schools, okay, Christian missionaries help in educating India would be required. Okay, so that is why they kept this rule 60%, 40%. At least 40% you give it for open. And moreover, as I told you, the minority children should not uh, excluded, meaning assume that all 100% of the students are belonging to one community, minority community only, Muslims or Christians, no people from other community. School is a place where there is not only transformation of knowledge, but socialization takes place. You learn from others, you integrate with others, you learn to live, you learn how to live in the future society as an adult. Okay, so future reality is given to you in school. So you will face people from different religion, caste, gender, and try to understand their needs, requirements, their perspectives, so we can live harmoniously. So that is why minority education institution, the 40% seats should be open, and it is also there is a demand even now. There is a demand that a lot of people want to study in Christian education institution. Okay, because of the quality of the education that is provided there. Okay, so automatically get filled. Okay, in fact, many of the Christian education institutions, they do not have enough students. There is only 20% for their own students, and remaining 80% is from other communities only. Okay. Okay, Article 32, constitutional remedies. Okay, what are the constitutional remedies? Before seeing what are the constitutional remedies, this article is called as the soul of the Constitution. Okay, it's called as the soul of the Constitution. Why it is called as the soul of the Constitution? Is because it gives life to the principle of constitutionalism. Okay, so soul of the Constitution and life, to principle of what is constitutionalism. Okay, see, constitutionalism means limitation of the power of the state. The word constitutionalism means Okay, if power is given to any institution, whether executive, legislature, or judiciary, their power has to be limited. If you don't limit the power, they may misuse the power. Okay, so the principle of constitutionalism says that the power should be limited. Indian constitution, which part of the constitution limits the power? You tell me. Which part of the Indian constitution limits the power? Already we have seen in the introduction class. Part 3 of Indian constitution, fundamental rights part. Very good. Fundamental rights part. Okay, so what is this part 3 of the fundamental rights part? It ensures the state is not interfering in your personal lives. It limits the power of the state. Okay, so Article 32, whenever your fundamental right is violated, Article 32 ensures your fundamental right is restored. It gives life to fundamental rights. If not for Article 32, fundamental rights would be mere declarations. Article 32 only ensures fundamental right is restored when it is violated. So Article 32 gives life to fundamental rights. Fundamental rights in turn gives life to principle of constitutionalism. It gives life to constitution itself. Since it is giving life to the constitution itself, we are calling it as a soul of the constitution. So what does Article 32 say? Article 32 says, whenever your fundamental right is violated, you can go to Supreme Court. Directly you can knock the Supreme Court, Delhi. Then there is another article, Article 226, it says that you can go to the High Court. So even if fundamental right is violated, you can go to the two courts, not the lower courts. Go to the Supreme Court and High Court, only to the higher courts, not to the lower courts. Why is it so? Why only Supreme Court and High Court? Why not lower courts? Yes, anybody? Because High Court and Supreme Court is the court which is having expertise to deal with fundamental right violation cases. See, the most difficult part in Constitution is fundamental rights part and DPSP. Compare that, if fundamental rights and the silent features, these only is very, because conceptual. Okay. So any case related to fundamental rights, we want the court to interpret, okay, give the judgment properly. Okay, so they only have the expertise and experience. Moreover, speedy justice. Fundamental rights is very fundamental. When it's violated, immediate. Suppose you are saying that lower court you can go, after lower court, once again appeal in the High Court and appeal in the Supreme Court, the process takes very long. So your fundamental right is violated, immediate remedy has to be given. That is why High Court and Supreme Court, not the lower courts. But you may be thinking, no, sir, what if there's no access to justice? Some remote corner of the country, fundamental right violation is taking place, whether the person may travel up to the state capital or the country's capital. Would it be difficult for that person? Yes, it will be difficult. Okay, very, very difficult for the person. That is why Parliament can empower a lower court to listen to fundamental right violation case. Okay, who can empower? Parliament can empower. Lower courts. Okay, but so far we have not empowered any of the lower courts to listen to fundamental right violation cases. This is the Supreme Court and High Court is listening to this case. What the Supreme Court may do when a case is filed before it. Okay, when a case is filed before the Supreme Court, They can issue writs. Okay. So what is a writ? Writ is an order issued to restore fundamental right. Writs means it is an order issued to restore right. Now you may be asking, sir, why can't they say it's simply judgment or court order? We want to differentiate between ordinary court order and order to restore rights. So that order issued to restore rights is called as writs. What are the writs? Habeas corpus, mandamus, prohibition, certiorari, habeas corpus, mandamus, prohibition, certiorari. And then quo warranto. Okay, writs can be issued. Now, sometimes in newspapers, they will use writ in a different connotation. When judiciary use the word writ, it means the order issued to restore rights. But when bureaucrats, IAS, IPS officer are using the word writ, it means maintenance of order. The word writ means maintenance of order. Maintenance of law and order. Okay, suppose there is a right-like situation, police will say the writ of the state has declined. The right situation is controlled, they'll say the writ of the state is re-established. Okay, like that they'll say. Okay, now I'll explain habeas corpus, mandamus, prohibition, etc. later. Now let's see the third provision. Okay, it is mandatory for the Supreme Court to take up to a fundamental right violation cases. According to Article 32, the third point is mandatory for Supreme Court to deal with fundamental right violation cases. But for High Court, it is not mandatory. For the High Court, it is discretionary. Okay. Now you may be asking, sir, why High Court is discretionary? When fundamental right is violated, you knock the court of law, and the court is easily saying, no, that I will not take up the case. Is it appropriate? No, it's not appropriate. Okay. So what should be done? The High Court, when it is taking up a case, if it feels the case is very difficult, it needs interpretation of the court of law. So they can refer the matter to Supreme Court. They can say, you please file the case in the Supreme Court. Okay, even the case is of national importance like that. That is why we are saying it is discretionary for High Court. Otherwise, High Court also will take up the fundamental right violation cases with the utmost emergency. Because fundamental right is violated. Why it is mandatory for the Supreme Court? Because the Supreme Court is the guarantor of fundamental rights. Supreme Court is the guarantor of fundamental rights. Why we are saying Supreme Court is a guarantee of fundamental rights? Okay, this is the last resort for any citizen. Okay, when their fundamental rights are violated. Now, based on Article 32, they have done three things. Okay, based on Article 32, they have done three things. Okay, that is no locus standi principle. No technicalities. So motor action can be taken. Okay, no locus standi principle, no technicalities, so motor action. Okay, now I'll explain one by one. Locus standi means in order to file an ordinary case, you must have a stand in it, or you must be the affected party. So if you and your friend is fighting, I cannot come and file a case for it. Either you or your friend only should file a case. In ordinary cases, there must be locus standi. A third party cannot initiate. Yeah, PAL is an exemption. Public interest litigation is an exemption. But in normal cases, fight between the two, locus standi principle must be there. So, but for fundamental right violation cases, the court has done away with the principle of locus standi. They have said no locus standi is required. Okay. Then technicalities. See, in order to file a case in the Supreme Court, you must follow an order. Okay, format. The format has to be followed. If the case is not filed in a particular format, the case itself need not be taken. So judiciary, just because the case, there may be a real case, but just because it's not filed in the required format, it can be dismissed. Okay, there is no technicalities. That's fine. See, locus standi means only the affected party can file case in ordinary cases. But in fundamental right violation cases, even anybody can file. Okay, because the victim of fundamental right violation may not be able to file the case. So any citizen, concerned citizen can file a case. At that time, court will not ask what is your locus standi. So no locus standi. Technicalities is no format is required. Even if you write a complaint in a piece of paper, you'll be accepted as a complaint. Okay, no issues. They'll accept it as a complaint. Even a postcard, you write a postcard, they'll take it as a complaint if it is a serious matter. There has been instances in the court of law, a postcard has been accepted as a petition. And suo motu action. Normally, the courts cannot act by itself. It should wait for a petition to come before it. Okay, it is called as judicial restraint. Judiciary has to restrain itself. It has to wait for somebody to petition before it. But in case of fundamental right violation cases, we have seen that judiciary itself taking up the case, suo motu action. Okay, any doubts in this? Okay, so these three things, they are deriving from Article 32 only. Article 32 says that it is mandatory for Supreme Court to deal with fundamental right violation cases. Supreme Court is the guarantor of fundamental rights. So they don't look for the locus standi principle. They don't worry for technicalities. They go for suo motu. The word suo motu, suo means self, motu means action. Okay, so self-initiated action. Done. Any doubts you can ask. Okay. High Court is discretionary in dealing with fundamental rights is because whenever a complex case is coming before it, when the High Court feels the case should be listened by the Supreme Court, so at that time, the High Court can ask the petitioner to go to the Supreme Court. It may refrain from listening to the case. It's not that High Court will simply say no for the case. Only in case the particular case has to go to the Supreme Court, High Court will ask the petitioner to go to the High Court. Sorry, the petitioner will be asked to go to the Supreme Court. Suo motu action only for FR, yes. Only for fundamental right cases, suo motu action can be initiated against judiciary. There are instances in which judiciary has gone suo motu for some other cases also, but suo motu action by judiciary can be taken only for fundamental right violation cases. Okay. When the term writ petition comes in newspapers, when bureaucrats are using the word, it means it is maintenance of law and order. When the judiciary is using and it is coming in the newspaper, then it means uh, an order issue to restore rights. Okay, fine. So habeas corpus next is we have to discuss habeas corpus. So we are actually going on track. Okay, I thought I have to take classes to you from Article 19. That is why I asked for extra hours. Okay, and the religion part also. No, usually it will take a lot of time because people will have a lot of questions. Okay, related to freedom of religion, but your batch maybe because you are only 30 people, number of doubts is less. Okay, so usually a batch of 100, 110 and all. It will take around 6 hours to complete that 25 to 28, but completed that for you in 3.5 hours because of questions. Okay, content is the same. Okay, fine. I think today we will wind up by 7:30 itself. Tomorrow also 7:30 itself we can wind up. Not a problem. Okay, tomorrow regularly 2 to 4:30 and then 5 to 7:30. Like that, we can do it peacefully because we are on track. Okay, no need to worry. We can comfortably finish. Okay, your syllabus. Okay, any questions? Okay, so we'll wind up the class here today. Okay, so tomorrow freshly we will be talking about the various writ petitions, Article 32, 33, 34, 35, and then directive principles of state policy as well as fundamental duties. Okay, fine. Okay. Yes, Kishore. Now I can sit for a answer question answer session. Okay, you can ask the doubts. Yes, Kishore. Can unmute and speak.
Sir, good evening, sir. It has been so long.
Good evening.
It has been so long, sir, to come to your classes.
Sorry.
It has been so long to come to your classes, sir. It has been a while, like maybe a month or 2 months. We are
Yeah,
attending the sessions.
uh, because we have weekend optional classes were there, and I had another work of completing the political science notes. Okay, which was promised earlier, but due to corona issues, I was not able to complete. So I've had to organize that. Okay, so even 3 weeks I was not taking GS class for weekday batch also.
Okay, okay,
That
sir.
was the main reason. Huh?
Hope you are safe and everything is going fine, sir.
Yeah, I'm fine. I'm fine. It was because of other academic work only.
Okay, sir. Sir, I have few doubts in the Article 22 part 2, sir. Okay. The class 2.
Please.
The protection available during the preventive detention. You told that 2 months whenever the product preventive detention is being happened, there is a 2 months period. No, sir. What is significance? The two
See,
months period.
I'll explain it. If as of now it is 3 months only, but they made a change to 2 months. Okay, but they have not notified it yet. See, any law, any decision of the government, if it is to be implemented, it should be notified. Notification means they'll tell from this date onwards it is implemented. If government does not issue notification, the law will never come to force. The decision will never come to force. So they have made this change in the constitution, telling that from 3 months to 2 months. But army and the law enforcement agencies, they came up and said to the government that if you are reducing it to 2 months, we will not be able to maintain law and order. So listening to army and other people, the government did not notify the change. So now 2 months is not relevant. Okay, so if they 3 months is the present scenario.
Okay, sir. So the advisory body has to be formulated whenever the preventive action is
Yeah,
being
after 3 months. After 3 months,
after
still if you want to extend the detention, advisory body has to be constituted.
the same has been done in J&K, right, sir? Jammu and Kashmir.
Yes. In J&K, it is PSA Act. PSA Act, I think you can keep people in preventive detention until 1 year.
Okay, until only. Okay, sir. Thanks, sir. Hope this passes the government will go through.
Thanks, Kishore. Thank you very much for that. I wish you all happy new year, right? This is the first class I'm taking for you. And a studyful year, I should say. No, not only happy, studious and examination year. Any other doubts? No, see, preventive detention is legal. Okay, so locus standi principle, yes, it applies. Case of preventive detention. See, if the preventive detention is legal, okay, you cannot file writ petition itself. Okay, it's not a violation of fundamental right. So locus standi is not possible during preventive detention. Or we should say that concerned party only should file a case. Now, if the preventive detention is illegal, there is some issue, then locus standi principle will apply. Anybody can file. As long as preventive detention is legal, it is like a normal case only. Only affected party should file a case. Okay, so we'll wind up the class. Okay, see you tomorrow. Okay. Okay, there is one more question. Sir, can the child below 14 years can work in hazardous work due to no. Children below 14 years can work in their family business, but apart from their school hours only. Okay, right now after 2016, the children cannot work in any work, even due to economic condition. No. PPTs, this is just like I'm using the PPT like a board only. Okay, so I'm not willing to share the PPT. I'm sorry. See, in case of Somnath temple or some other temple, when the president visited later, if they have done the puja or purification ceremony, okay, and that is actually a kind of untouchability, a practice of untouchability. The president did not file a case, or others also did not file a case. Okay, active citizens should have filed a case. Okay, to do with that action. Okay, now the affected party or the people belonging to that religion can. You're asking whether the Supreme Court can take suo moto. It is the discretion of the Supreme Court whether they are taking suo moto action or not. Yeah, before 2016, children can work in non-hazardous industry. Yes, before 2016. After 2016, they can't. Yeah, it is a problem. Okay, especially Lila Raja visiting Tiruvannamalai temple and the same. Yes, it is an issue that is going on. Nobody petitions. Okay, they do not care. Okay, so I think they felt that at least now they are able to enter into the temple. Okay, so let them do whatever they want. Okay, earlier even entering the temple is a not possibility. If this keep on happening, definitely one fine day somebody will file a case. And if they're filing a case, there will be instruction from the court of law that such kind of ceremony should not be conducted. But now people will say it was not a purification ceremony, it was some other puja. Okay, it was a regular puja. Simple. No, you can play with words. Thank you. Thank you for some many of you are wishing me happy new year. Thanks all. Okay, done. We will meet tomorrow. Okay. Sleep tight. See you tomorrow.